And good evening. Our Washington County Quorum Court is now called into order. Got a full house, got a full agenda. If we have all our seats filled, I'm going to ask those who are standing, if they want to, they can go ahead and stand in the foyer or sit in the foyer. And if you are speaking any time during the meeting, go ahead and stand in the doorway as we ask the public to come in and make their comments, whether they're for any of the support of appeals or against or what have you. So again, if you don't have a seat, go ahead and take a chair in the foyer, and then again, at the appropriate time when we have the public comments, you can go stand in the door and you take your turn to come and make your comments here at the desk. We'll go ahead and get started. We got a full agenda. With that, we're going to have J.P. Marty. Will you lead us in prayer and pledge?
Our Father, who art in heaven, hallowed be thy name.
Are we good, Bob? Okay. At this point, we're going to go ahead and get started. We need the adoption of the agenda. Is there a motion to adopt the agenda? Are there any changes? J.P. Washington?
I move that the agenda be adopted.
Got a motion to adopt the agenda. Second by J.P. Duncan. All in favor? Aye. Those opposed?
No, I've got to have my microphone on.
Well, so the agenda has been adopted. J.P. Madison?
Well, with all due respect, I had my microphone on before you recognized J.P. Washington. Pursuant to section 2-31.1 of the county code, I wanted to add under other business a discussion of the discontinuation of the Zoom meeting. It says that any justice of peace may also request any relevant item be placed on the committee agenda or may bring such up under other business. Thank you.
So there's a motion to amend the agenda by adding a discussion on the continuation of Zoom to the agenda. So again,
With all due respect, it just says that we can add it. It doesn't say that it has to be part of the agenda.
But the agenda's already been published and put out.
yeah, so that wasn't on there. So I would ask if we have the body vote to add that on if we're going to amend the agenda, because it wasn't on the agenda. It was published already. So is that, go ahead, JP Hires. Okay. All right, so we have a motion to amend the agenda and a second by JP Hires. All those in favor? Aye. Those opposed? No. Ms. Patty, will you go ahead and take the roll, Ms. Martin, make sure we get that on accounted for? Let's go ahead and just do the,
Patrick Deakins.
Point of order, please.
Hold on, Patty.
Okay. The county code doesn't require, this just says that I can ask that it be put under other business. There's no requirement that the agenda be amended for this. I read to you what county code says. Any justice of the peace may also request any relevant item be placed on the committee agenda or may bring such up under other business.
Has our policy been to have the agenda be amended by the body?
No, not for that, not for the purpose of bringing something up under other business.
Counselor, will you have,
So with the point of order, you've made a ruling that it has to be amended, and I believe, are you wanting to treat this as an appeal of the chair's ruling to the body? Have to mic her up.
okay.
No, I'm asking that this body follow its own ordinances.
Okay,
It's
but
not a
there-
procedural ruling. It's not a ruling, a parliamentary ruling. It is a request that we follow county ordinance. That's different from a parliamentary ruling that is appealed to the chair.
Okay, well, the chair still presides, so you would have to appeal the chair's decision under any body,
Okay,
under
well,
any rules
let's-
or regulations.
Let's let the chair be the talker.
Well, and that would be what I would say.
Okay, so you're refusing to follow county ordinance.
No, we just voted on the not approving amended agenda. Ms. Patty, go ahead and run the roll.
Lisa Ecke,
The voting on. We're voting on whether to approve the amendment to the agenda.
Sam Duncan,
No.
Shonda Washington. Yes. Eva Madison. Yes. Robert Dennis. Suki Hires. Yes. Evelyn Rio Stafford. Yes. Willie Lemming. Yes. Jim Wilson. No. Butch Pond.
No.
Lance Johnson.
No.
Shannon Marty. No. Sean Simons. No. Bill Essery. I have 5 for, 9 against, and 1 abstention. So it failed.
All right, so the amendment does not pass. All right, so we have a motion to approve the agenda, the adoption of the agenda, a second by J.P. Duncan. All in favor? Those opposed? Ayes have it. We will go ahead and move to the preliminary motions. Are there any preliminary motions? Again, this is where we ask the ordinances be read by title only. J.P. Duncan?
Judge, I move that the ordinances be read by title only.
Do we have a second? And a second. We have a motion and a second. All in favor? Those opposed? All right, that passes, and so we'll be reading ordinances by title only. At this point, we'll go to citizen comments. Again, if you have a comment and you're out in the foyer, just stand at the door and we'll have you come in and visit. But again, our allotment is 15 minutes for public comments. You can come and visit with us and speak to what it is that you would like to share with us here. And we have 3 minutes. We ask that when you come, please state your name and where you live. With that, come on. Good evening. Yep.
My name is Max Perez. I live in Springdale, and this is your comment.
Needs to hit that.
Hit that button on there that has the person on there. Okay, now say it again. Your name is,
Max Perez. I live in Springdale. Oh, that's it. So I'm just going to read this off. The last year has been really hard, and I know you all are doing your best. You can under the really challenging circumstances, but seeing that no one from the marginalized community is on the court, I am not sure you realize just how helpful and important it has been for the community to participate in county government virtually at meetings. I have seen now being able to attend meetings over Zoom and actually getting to speak during comment times has increased community involvement and knowledge of our county government. Neighbors who have never followed the court or spoken at meetings before this are now following the court and are engaged. This is so important, especially for those who do not always feel like their voices are heard or that they have a seat at the table. This is what they do, and that is empowering. I realize that when the governor's latest emergency declaration expires at the end of May, unless it is extended, meetings must be held in person. However, it'd be a wonderful community service for the court to allow people to continue coming to these meetings in Zoom. At last month's meeting where Judge Wood rotated between in-person speakers and online speakers, I thought that went very well, If that could be continued, I know it would help bring more community involvement to our county government. I also want to bring this to your attention and respectfully ask that you continue to allow the community to participate virtually, even after you go to all in-person meetings, and to personally make you aware that this is just a really helpful thing. Like, for example, I don't have meetings today, but most days I have meetings until 5. And so, I'm really busy, and I wouldn't be able to come here and most evenings, so that Zoom meeting.
Good evening.
Hi, good evening. Get my mask off so I can talk better. Good evening, Justice of Washington County. My name is Sherry Main. I live at 15574 Riches Road, Fayetteville. I do not live near this quarry that is on the cup tonight. However, I do live 1,070 feet from the HRM quarry on Hamstring Road in Fayetteville. I have followed this cup through the planning board ZBA meetings via Zoom over the last 14 months. I made public comments during the meetings in reference to several issues that were brought up by the neighbors around the Springdale quarry. Most of the opposing neighbors talked about their personal experiences living and coexisting with the rock quarry. Some of the issues mentioned are the history between the quarry and the neighbors hasn't been good. HRM is not a good neighbor. Number 2, crushing, blasting, noise, air quality, and reduced home values. Number 3, enforcement and monitoring compliance. Number 4, burn, screening, and trees. My comments to each issue. Number 1, being a good neighbor goes both ways. Communication is a must. Valid concerns and complaints should be reported to the proper enforcement division. Research the DEQ website and know where to file your complaints. Washington County planning is not an enforcement tool. Number 2, blasting is regulated by the independent company hired by Rodgers to drill and set off charges. The blasting report for each charge is documented and reported to the Department of Labor Division for blasting. The crusher noise and air quality are regulated by the DEQ, and complaints can be filed online through their website. Inspections are only on a complaint basis for compliance and enforcement. Reduced home values, in my opinion, are market-driven. I researched public records on homes and lots purchased and sold in the Friendship View area. It seems the quarry didn't detour the neighbors' decisions to buy lots and build homes in this area, even with an existing operating rock quarry. Number 3, Rodgers has agreed to hire an ombudsman for their neighbors to report any compliance issues to, and I understand this will be an engineer firm. This will help with the communication of problems and issues to Rodgers. Number 4, Rodgers has agreed to the screening for the neighbors and a dust abatement plan. Setbacks and berms are required for the DEQ permits. Rodgers has the required permits with DEQ as in compliance. They are in compliance. The most recent stormwater runoff and air quality complaints were investigated by DEQ, and the issues were resolved with no enforcement action. The Hunt family has agreed to designate conservation and preservation easements to assure their neighbors that live in the Hunt's lakeside estates will be protected from further quarry expansion. The 40-plus conditions placed on the approval of this cup for Rodgers is an extensive list.
Ms. Main, go ahead and wrap it up.
It is my understanding, I'm almost done. It is my understanding the applicant, Rodgers, has agreed to these conditions placed on the cup and offering to go above and beyond some of the requirements, just to show good faith and be a good neighbor. I ask that you consider approval of this cup for the reasons I stated. Thank you.
Thank you, Ms. Main. Public comments.
Good evening, Kyle Smith from Fayetteville. I too would like to encourage you to resume the Zoom meetings. It's a full house. It's a little spaced out, so the capacity is low. We've got folks standing in the lobby, and we've made a situation where the only way that someone can come talk to you is to come be in a room where they probably won't feel comfortable and almost certainly are not safe. On top of all of that, I'm hearing from folks out in the community and seeing on the YouTube channel that the live stream isn't even running.
Thank you. Public comments.
Good evening, Sarah Moore, Fayetteville, Arkansas. I reached out to all of the JPs and to Judge Wood in regard to the announcement that came early this week about discontinuing the Zoom meetings. And I really urged that we would amend the agenda tonight and would have a discussion about what the merits had been of participating in Zoom, as well as what the financial investment had been. I have followed the court very closely since January 2019 and attended almost every meeting the court has had. During the last year, we had a pretty contentious conversation about the thousands of dollars that we were going to invest in these sound systems and different electronics in the room to easily allow for the use of the online platform. Zoom is what we were using to facilitate our meetings with the public and with elected officials. Much to many of our surprise, we felt like on the resident side and the community members were getting a lot of benefit from Zoom. Many of us were worried about our immune-compromised family members, and so we were doing our diligence to stay at home as much as possible, also to provide additional distancing for other people that did have to come in person. Also, as you've heard from others, and we've discussed this at length, the state of Arkansas and Washington County has a very impoverished population, which has been pressed and stretched additionally because of the pandemic. People are having trouble putting food on the table and are struggling to maintain their transportation and their housing. One of the things that we've been able to provide with Zoom is we've actually enfranchised more people to participate in their county government. And I think that we all think it's incredibly important to create as transparent as possible a government process. And so I would really encourage there to be a full public conversation with the Quorum Court participating along with Judge Wood to talk about what the financial outlay had been in regard to the equipment we purchased, how much Zoom cost, the pros and cons between what weapon, the hurdles that we think that Zoom has presented to us versus what has been the benefit. And I would really charge us with, I thought this was an improvement that was something that we could invest in for the future because of the fact that we had really engaged with the rest of with additional community members. When I started coming in January 2019, there was a mention from a JP that you could take a bowling ball and you could roll it down the middle of this room and you'd never hit anybody. Well, tonight you would hit a lot of bodies. So there's a lot of folks that want to participate, and I would hope that each and every one of you represent constituents, and you would want them to be as a part of the process as possible. And so having this conversation about the possibility of looking at doing this hybrid version for the next year, and then let's talk about how did that go, or if it's 6 months at a time frame, and then evaluate whether or not we want to do that into the future. But just cutting it short without that conversation doesn't feel like the right thing for the people of Washington County. Thank you.
Thank you much more. Public comments.
Josh Moody, Fayetteville. I'm wearing a T-shirt that says "We're all in this together." I know JP Hires is familiar with it. Some of you others may have seen it as well. We are all in this together. I'm just going to kind of add to what several other people have already said. Limiting.
Where are you from?
Josh Moody, Fayetteville.
Fayetteville. Okay. I missed that. I'm sorry.
Getting rid of virtual access, in addition to discontinuing the mask mandate in this room, while continuing to social distance in this room, it appears at worst that some of you might be intentionally limiting public access to these meetings. At best, it's bad optics, and it seems like you might be intentionally considering who you do not want to be involved in this meeting. To me, just looking in the room, it seems like it would make more sense to continue the mask mandate while adding more chairs into the room so that more people could continue to participate at the very least. As the others have said, continuing the virtual access allows other people throughout the county who can't make it here on 6 o'clock on a Thursday night to continue to participate because we are all in this together. Thank you.
Thank you, Mr. Moody. Public comments. Good evening.
Good evening. Hi, I'm Ashlyn Gagnon of Goshen, Arkansas. I have spoken with many of you this week, so I'm going to make this very short. I've spoken with you. Some of you are actually able to come out to our property. I am one of the owners of Orthodox Farmhouse Brewery, which is number 10 on the agenda. My husband's the other owner, Jesse. He's here. Because we have spoken with many of you have looked at the presentation that we sent. I'm not going to take time to go over more in depth about our vision. I just wanted to say that the Goshen community is a community that is growing. It's a community that has strong agrarian roots, and we hope to create a space where the community can come together for connection. A farmhouse brewery is a family-oriented place. It's where people of all ages can come, and our goal is that we can serve an excellent product in a place where all members of our community can come and celebrate the best parts of our Ozark culture and history. So we've been in this process for about a year. Up to this point, we have spent a significant amount of personal finances just to get you where we are, from the architectural documents and things like that, our development with our engineering firm. And so all of that to say, because of pandemic-related delays and everything like that, it's taken us time to get here, and we are so ready to get this business open. And so we would just ask that you consider that in the decision tonight, as we believe from the outpouring of community support we had 26 letters of people coming and giving their support from our community, 4 of which were directly from our road. And so we're just so grateful to have the community support, and we're ready to get open as soon as possible. Jesse and I are here to answer any questions that you have directly when our project does come up. So that's all I just wanted to say. Thank you so much.
Thank you, Ms. Gannon. Public comments. Public comments. About 45 seconds left in the public comment time.
I can just, Gladys Tiffany, Fayetteville, and I just would like to add my voice to those who really would like to see the Zoom meetings posted again. Just that encouragement.
Thank you, Ms. Gladys. With 22 seconds, public comment, anyone?
I don't know if I'll make it that many seconds, but I'll go as quick as I can. I'm Brian McDuffie, and I live at 21734 Friendship View Drive. And I'm here about the quarry situation. I think you've got lots of letters from us talking about all the details, so I won't drill into any of the details. I would just ask you to consider the magnitude of the list of details: the falling home prices, the damage to the roads in our area, the dust and the watery slime stuff that we have to drive through and wash off our cars, the thundering noise from the rock crushers every night, well, not every night, most nights, the massive size of the expansion, all the 80,000-pound dump trucks that are driving down that curvy road there. And by the way, the busiest time for the dump trucks happens to be the busiest time for the school buses in the morning.
All right. You want to go ahead and wrap it up, or you'll have an opportunity, obviously, at the time when the agenda item comes back up.
There's a few other things on the list, none of them on the list that the lady just mentioned there. Those really aren't the biggest concern. So it's just a long list. It's a really long list, and we just ask you to consider the magnitude of that list when you're looking into this quarry expansion. I appreciate your time. I
Thank you.
apologize for going a couple seconds over.
Thank you much. We're going to go ahead and move to item 6, which is the approval of the minutes. Got a motion to approve the minutes, and it's by J.P. Lemming. A second was J.P. Rio Stafford. Or was that Pond? I didn't. J.P. Pond. All in favor? Aye. Those opposed? All right, the minutes have been approved. Item 7 is a judge's report, and I will not have any long report. 2 items. You have your disposal report in your packet, as well as you should have been sent your audit from legislative audit this probably last week, but it's also posted online. With that, we're going to go ahead and move on to item 8 because of the length of the agenda. Unfinished business. Counselor, will you read the ordinance by title only?
Item 8 is an ordinance establishing the procedure to be used for the introduction of ordinances and for other purposes.
J.P. Wilson.
1-0-022, 8.1.
There's a motion to approve item 8. Is there a second? Second. There's discussion?
Can we amend that? Can we take Article 6 out of that? Or change it to maybe half the time?
Motion to amend is proper at this point.
Are you asking are you looking to adopt an amendment to
I'd
the
like to
ordinance?
amend that where maybe every 3 months it can come back up. Let's don't wipe it out for a year.
Item 6, I'm trying to remember reintroduction. Okay, so there's a motion to amend the ordinance. Is there a second? There's a second. Is we gonna do a vote or all in favor? Let's do a voice vote. All in favor of amending the agenda to amend the ordinance on item, Article 6 in the ordinance? Ordinance shall not be reintroduced in less than 1 year. If one fails, adoption of the court unless it relates specifically to the annual budget. Your suggestion is to move it to 6 months, and we have a second by J.P. Madison. All in favor of amending the?
6 months or 3 months?
He said 6. Well, he just said 6 months.
Point of order, Judge, could you ask the folks to push the microphone?
I'm sorry, that's me. That's me.
Some of us that are challenged.
Let me go to, all right. JP, let me pull your mic down. All right. So you're asking the item Article 6, go ahead.
And let's do it for 6 months
Okay.
instead of a year.
And the second is JP Madison? All right. So it's to amend the ordinance for 6 months as opposed to a year. So it would read as what, Counselor?
Article 6 would read, an ordinance shall not be reintroduced in less than 6 months if it once fails adoption by the Quorum Court unless it relates specifically to the annual budget.
Okay, so you heard the amendment. All in favor?
Aye.
Those opposed?
No.
All right, Ms. Patty, let's go ahead and do a roll. This is a roll to see the adoption, the amendment, adopt the amended to the ordinance, amendment to the ordinance for 6 months.
Patrick Deakins.
No.
Lisa Ecke. No. Sam Duncan.
No.
Chandra Washington. Yes. Eva Madison. Yes. Robert Dennis.
No.
Suki Hires.
Yes.
Evelyn Rio Stafford. Willie Lemming.
Yes.
Jim Wilson.
No.
Butch Pond.
No.
Lance Johnson.
No.
Shannon Marty. No. Sean Simons.
No.
Bill Usry.
No.
I have 4 for, 10 against, and 1 abstention.
Okay, so the amendment fails. We're going back to the original ordinance, the J.P. Wilson, and did we have a second? J.P. Ecke with a second. Any other discussion? All right, let's go with J.P. Hires. J.P. Hires.
Thank you, Judge. Whew, okay. I appreciate J.P. Lemming's attempt to amend it, but even with that amendment, I still would not be able to support this ordinance. We do have a procedure already for ordinances. We've been using it for years. This particular ordinance will have the effect of making sure that all minority ordinances are completely left off of any agenda. And so due to that, I absolutely cannot support it. Thank you.
J.P. Rio Stafford.
You turned on
There
mine.
you go.
Great. All right. Thank you, Judge.
I actually have an even bigger issue with this ordinance. The way it is written right now, it actually would repeal public comment entirely. And we have a room full of people here tonight, who wouldn't be able to speak under the rules of this. It's basically a combination of Article 5 and Article 8 together would repeal all of our public ordinance, or our citizen comments. Article 5 says, once an ordinance is placed on agenda, Robert's Rules of Order in its most recent version shall govern, except where they're in conflict with the general laws of the county and the state. There is no citizen comment in Robert's Rules, nor is there citizen comment under state law. Those were created under local ordinance of the Quorum Court. And Article 8 says any ordinance or portion thereof in conflict hereto is hereby repealed and replaced. So essentially, this ordinance would repeal citizen comment. That was put into place by ordinance number 2016-06, which I have here. My second issue with this is that under Article 8, we don't really know what other unintended consequences of this ordinance are, because our ordinances haven't been codified into Muni Code in several years. The public doesn't know what other ordinances or portions thereof might be repealed and replaced. So I think we need to study this, take a closer look at it. I don't think it's ready for prime time yet, and I think it could have some other unintended consequences besides repealing citizen comment. So my view is, if you want to repeal citizen comment, vote yes on this. My colleagues should vote yes on this, but if you want to keep citizen comment, vote no. Thank you.
J.P. Wilson?
Yes, there is no intention for this to do away with citizen comment. The two purposes that this was intended for are to see that ordinances are presented to the appropriate committee first to allow for more discussion and development of the concept before presentation to the full Quorum Court. The second purpose is that since the Quorum Court thoroughly discusses and debates issues when presented before it, that an issue only be presented once per year unless it relates to the annual budget process. Thank you, sir.
J.P. Parn and then J.P. Madison.
Yes, I have a question for the county attorney, and I'll try to make this as plain as I can. We, the court, have always had the ability, if, let's say the scenario is an ordinance fails, and then, of course, some amongst the majority who voted no on that ordinance, if you have a couple of those individuals change their mind because of some unforeseen consequence, a no voter, somebody that helped kill that ordinance, has been able to come back and say, I shouldn't have done this because of this or that or thus and such. Will that be eliminating someone among the majority who voted no from coming back at the next meeting and say, we made a mistake here by voting no?
Under Robert's rules, if you vote, if you're with the majority and someone from the majority would like to bring something back up, they can still do that. So this doesn't change Robert's rules.
Okay,
now,
this-
that's in one meeting, in one setting. So at a next meeting, then that rule doesn't play, it's not in play because that issue is considered disposed of. This ordinance, however, does still have a provision that would allow a 2/3 vote of the member of the majority of the Quorum Court to allow an ordinance that does not relate to the budget to suspend the rules and add something to the agenda.
Thank you.
J.P. Madison. Did it come on?
Okay.
There you go.
Thank you, Judge. All of us were elected to represent equal districts in Washington County, but this ordinance is nothing but an attempt to silence several of those districts, to prevent some of us from being able to bring forward ordinances. I think you all witnessed when I simply tried to add a discussion point to the agenda, how hard that was. People don't want to have discussion on this body. They want to control the agenda, and this is one method of doing that. We went from having a budget committee of the whole for many, many years. It was very productive. And now we have a budget committee of 7 people. And now we're going to have every ordinance go through a committee where very few of us have a voice. And so this is not, we can call this efficiency, we can call it whatever we want, but this is an attempt to control the discussion and to silence people on this court who've been elected by citizens of this county. I asked the county attorney for an opinion. Not surprising, he 100% thinks it's a valid ordinance. I wrote back to him and said, well, I'd like to call your attention to an attorney general's opinion that says that state law, if state law requires that something be done by a majority vote, that we cannot, by ordinance, require a supermajority. And that's exactly what Article 4 does. Article 4 says that the only way out of this very strict parameter for introducing ordinances is for a supermajority to allow it to happen, which is exactly what multiple attorney general opinions say cannot be done. Mr. Lester never responded to my request that he evaluate that attorney general's opinion. So every citizen should be concerned when you cast a vote for your justice of the peace and then other members of this court try to take that voice away. I am not going to be quiet. If they think that this is some way to keep me quiet, I think those of you who've watched Quorum Court know that I'm not going to. I'll find a way. And so this should be an open, transparent process. Anyone on this court should be able to bring forward an ordinance and have it discussed and have it fairly considered. And we shouldn't be putting procedures like this in place to limit the voices of the voters. Thank you.
J.P. Washington.
Thank you, Judge. When this was first presented, we were told that the reason that this was necessary was because nothing had been done with Resolution 1979-01. That's the way that it was presented. So I'm a little confused because if we are trying to repeal Resolution 1979-01, then why is there a need for Article 8 saying that any ordinance or portion thereof in conflict is hereby repealed and replaced if we were only addressing the one for 1979? So I'm still confused on that part. Also, it has been stated that the rules are not clear. We had a very lengthy discussion, I know at the beginning of my term, about how we would bring ordinances to the court. And I can't find it. I looked online for the ordinance, but I remember us talking about that it would go through the committee, but there would be exceptions that would allow things to be brought to the full quorum court if it did not have an opportunity to go to a community first. So I don't understand what's not clear. I don't understand what is wrong with what we already have in place. I don't understand why we're citing Resolution 1979 and then going on to say that any ordinance in conflict is repealed and replaced. So I just wanted to know if someone could provide some clarity on that. And also another question I had is what constitutes a general ordinance? So does this mean that if it's something we consider an emergency, that we can bring it to the full quorum court? And if that's the case, then what constitutes an emergency? What is the definition of an emergency ordinance? So those are just a few of the questions that I had that were not clear to me.
J.P. Wilson, if you wanted to address any part of that, otherwise I'll ask the county attorney to also, yours is specific to this particular ordinance, and then in general, in ordinances in general, from the county attorney.
I'll defer to the county attorney for answering those.
All right, county counsel.
Well, I would state that there are 3 different types of ordinances. You have your general ordinance, you have an appropriation ordinance, you have an emergency ordinance. And I believe under this ordinance, an appropriation and emergency ordinances are not included herein. Emergency ordinances are defined by state statute, and I will be happy to email all of you what that statute says as far as what defines an emergency. It has to deal with finding that there is some sort of danger or imminent threat to the health and safety of the county or property or something along those lines. I don't have it in front of me, but I'd be happy to get it to you. With regards to J.P. Madison's comment about my opinion, I gave my opinion to J.P. Madison. We looked at this extensively, and I believe it was very thorough in what we provided. My opinion does not change based on what was provided to me. You are not changing a state law. If that was the case, under that argument that this somehow changes or restricts something that state law allows, then all of your ordinances that say that things have to go to committee or anything like that would be null and void because it would violate state law. You, as the quorum court, have the right to set your own rules. There are certain state law requirements that you cannot make an ordinance to go around. An ordinance to pass requires a majority of the full body, whether they're present or not. To pass an emergency ordinance or an appropriation ordinance on one reading requires 2/3 of the full body, regardless of who's present and who are not. There are rules like that you cannot get around state law, such as an ordinance, if you were to enact, that says that we will continue to have meetings via Zoom after the governor's emergency order ends, would be a violation of state law. The only reason you can have those meetings is because there is a specific state law that says in the event that the governor has declared an emergency, you may, not shall, but may have electronic meetings via Zoom. Once that ends, doesn't matter what Washington County or any city or any other political subdivision in the state of Arkansas does, state law, until the legislature changes it, requires you to have those meetings in person only. So I disagree, J.P. Madison, that that you are violating any state law with this ordinance. I still stand by my very thorough and lengthy opinion that I provided to all of you that this ordinance is legal, and you have the ability as the quorum court to set your own rules.
Any other discussion before we go to public comments? J.P. Madison.
We are getting emails that the leak for YouTube is still not working.
Bob, if you're up in the box, can you look at that and see if we can get that going? At this point, okay. Public comments. Public comments.
I'm sorry. The meeting is being recorded. It's just not streaming live right now, but we're going to see if we can get that.
Thank you.
Beth Koger, Fayetteville, Arkansas. I would like to speak about this because I've been attending meetings since January of 2019, and I've never seen this be a problem. And I would point out that J.P. Wilson has been on the court like 2 months before he brought this forward. So I would like to hear an explanation, if J.P. Wilson could provide, how he came to choose 1 year as opposed to 6 months or 3 months. And also as to the majority making decisions, Judge Wood, that's the trouble with the majority deciding anything is that it shuts out those people who aren't in the majority. And that's a lot of people. JPs, when you're elected, you represent the entire Washington County, everyone. You don't just represent your district. And it's not fair when only the majority gets to decide who gets to speak and who gets to have a seat at the table. It's not fair. And I think this ordinance will have consequences that you aren't thinking about. And I would ask that you please consider that, and please don't shut out a large group of people. You're in the majority now, but one day you might not be. Thank you.
Public comments.
This is a comment that I'm reading for a teacher. She is a mother, just had a newborn, and she's just kind of concerned about being in
Go
public.
ahead, tell us who you are and where you're from.
Yeah, my name is Max Perez. She is a Springdale teacher, and she lives in Springdale, and so I'm going to be reading this for her. Ms. Brown is concerned with the agenda item number 8 brought forth by JP Wilson concerning the procedure to be used for the introduction of an ordinance. She appreciates the attachment of 1979 resolution to the agenda packet in the county services meeting from March, but there are several questions that have been yet to be answered. For example, since JP Madison's ordinance to use CARES Act funds for community use failed, does that mean any ordinance attempting to use CARES Act money, could that be reintroduced this year? Reading Arkansas Code to be specific, Code 14-14-904 under procedural rules and attendance meetings, sections I and M. It isn't clear if ordinance can amend resolutions. Can ordinance amend resolutions? The resolution from 1979 establishing procedures around the introduction of an ordinance does not include a timeline requirement for the reintroduction of a failed ordinance. It still has not yet been fully clarified why a year shelf life is a reasonable amount of time. Despite the court rarely seeing failed ordinances being reintroduced, the timing of when this ordinance was introduced makes it look like a reactionary move to silence JP Madison in pursuit to use CARE Act money for community purposes. The ordinance also appears to help you not have to deal with considering minimum habitability standards. JP Rio Stafford and her predecessor Sue Madison brought this ordinance about to ensure that community members have safe homes and apartments to rent, therefore prioritizing child welfare. If you can stand by your reasoning of voting down such an ordinance to ensure families are safe, then you should be able to withstand the criticism that comes from voting down by such a measure. Creating an ordinance that shelves minimum habitability requirements in the interest of the JP that perhaps isn't comfortable with getting the criticism from voting it down. Quorum Court should not be facilitating ordinances that serve the JPs and making them more insulated from criticism. Quorum Court should not be in the business of creating comfort for the JPs around their decisions. Elected officials will receive praise and criticisms alike. Ms. Brown is grateful to all the JPs that are still willing to listen, especially JP Simon and JP Madison. Community members want to believe that the court operates in good faith and has a capacity to cooperate for the benefit of everyone, but ordinances like these without in-depth explanation for the need of such an ordinance make the supermajority on the court look like they're using their raw power.
Mr. Perez, go ahead and start wrapping it up.
Yeah, neutralize opposing voices. That's it. Thank you all.
Thank you.
Well, I'm so weak, that's my second Pfizer vaccination for the 3.
You hit your mic.
Okay.
All right.
Kyle Smith, Fayetteville, again. Committee review is a very good thing, but we don't elect committee members. We elect JPs. I voted for my JP Washington to be a good general purpose justice of the peace. Not all of you are on every committee, as we've heard tonight. I'm thankful that my JP is on the finance committee. I'm sure that if I had a need, she would be my go-to person for any sort of county personnel issues. I just can't imagine what I would need that for. But I want to know that I have a JP that I've elected that has full access to introduce issues on my behalf, whatever it may be. If I have a law enforcement issue, I want to know that my JP, who is not on the law enforcement committee or jails committee, forget what I'll call it, I want to know that she has the same right to introduce an issue, a discussion item as any of you. Please don't disenfranchise entire districts by limiting your own ability to do what we elect you to do, and that's to watch over all of the matters of the county. Once something is introduced, if it needs further study from a committee, you can absolutely always refer it back. But requiring things to start in committees seems like an unreasonable step that will delay matters before they come to the quorum court. And I think you've proven that the majority here is already really good at silencing things that you don't want to take action on, and I don't believe that you need the committee structure to help you with that. Thank you.
Public comments.
Okay. I'm Lou Reed Sharp. I'm from Springdale, Arkansas, and I'm sure I won't catch anything, JP Dennis. Right. So I just, I've been attending the meetings through Zoom, and just as a layperson, it appears to me like there's a lot of effort to silence our voices. I mean, we thought we were having Zoom tonight, and it was canceled without notice. And now we have ordinance that potentially will prohibit us from discussing the CARES Act funding and the habitability standards. So if this ordinance retroactively, applies to those issues, it's dead in the water for another year. And the other thing I will say is I talked to the nonprofits that were brought up last month, Life Source and Life Ministries, and I want to clarify that Life Sources gets their commodity boxes once a quarter, and so that may be in fact why they have an abundance of food quarterly. And so many of the churches and nonprofits, we do collect information, so it's not like everybody can come in all the time and get anything they want. Everybody at Life Ministries gets food boxes once every 60 days, okay? So if you run out of food, then you have to go to another church or go do something else or get your food stamps fixed. But all of the churches and nonprofits I talk to, and this would be a good problem or a good solution maybe for CARES Act money to be used for, is they all need storage. They all need freezer space. When you get tons of frozen food at the Northwest Arkansas Food Bank and you have a need in Prairie Grove or Lincoln for it, the first thing you got to do is have a freezer. So, but the county could help those local nonprofits and those churches with simple stuff. If you don't want to feed people, help them store it. Right? They all need storage. It's just
Comments? Public comments? Public comments? All right, with that, Ms. Patty, go ahead and take the roll.
Patrick Deakins?
Yes.
Lisa Ecke? Yes. Sam Duncan?
Yes.
Shonda Washington? No. Eva Madison? No. Robert Dennis? Yes. Suki Hires? No. Evelyn Rio Stafford? No. Willie Lemming? No. Jim Wilson?
Yes.
Butch Pond?
Yes.
Lance Johnson?
Yes.
Shannon Marty?
Yes.
Sean Simons?
Yes.
Bill Usry?
Yes.
Ten for, 5 against, so it passes.
All right, that ordinance passes. Item 9, Council, will you read that one by title only?
An ordinance amending ordinance 2021-1 to revise the standing committees of the Quorum Court for the 2021-2022 term and for other purposes.
This ordinance is on the second reading. JP Madison?
Out of respect for all the people that are here for the CUPs, I'd like to leave this on second reading and have it advanced to third to spare everybody from another one of our procedural debates. So as the sponsor, I would ask that we just push this off.
All right, so this one will go from second reading, will go to third reading in May. We will move on to item 10. Council, this is new business. Council, will you read that one by title only?
An ordinance ratifying a conditional use permit recommended for approval by the Planning and Zoning Board. This is for the Orthodox Farmhouse Brewery.
All right, JP Pond.
Can you hear me now? I pushed the wrong button. I have gone out and visited these folks that are wanting to put in this brewery. They're family oriented. They want a family oriented business. They're having cooperation with their neighborhood. I don't believe this is going to be anything but a plus for the community. And so I would move that we pass 10.1.
It's only on its first reading, so.
Move to suspend the rules and move it to second reading.
There's a motion to suspend the rules and move to a second, seconded by, who's that? J.P. Lemming. All in favor?
Aye.
Those opposed? All right.
Move to suspend the rules and move to
Let
third and
him read
final
it.
reading.
Let 'em-
Okay.
Go ahead, Counsel.
An ordinance ratifying a conditional use permit recommended for approval by the Planning and Zoning Board.
Now move to suspend the rules and move to third and final reading.
Got J.P. Lemming asked to suspend the rules, move to a third and final, second by J.P. Ecke. All in favor?
Aye.
Those opposed? All right,
Move
Counsel,
to
will you read that?
pass. Oh, okay, I'm sorry.
Counselor, will you read that
I'll
one
let
for the
you
third and
read it
final time?
first.
An ordinance ratifying a conditional use permit recommended for approval by the Planning and Zoning Board.
Move to pass.
We got a motion to move to pass. I didn't get the second. Who was second? J.P. Madison. Any other discussion? Public comments? Public comments?
Will you let us know when it's open?
Public comments, come on.
I would love for us to get to public comments, but my question is, now that we passed item number 8, which appears to, as I mentioned before, the unintentional consequences of we've repealed public comment, has agenda item number 8 that we just passed go into effect immediately? No, okay. We're going to have to
comment.
resolve this at some point.
That was never taken out, but again, if there's more discussion we need to have on it, but public comments at this point in time on item number 9 with the Orthodox Brewery. Any public comments? All right, Miss Patty, will you go ahead and take the roll? Item 10.
Patrick Deakins? Yes. Lisa Ecke? Yes. Sam Duncan?
Yes.
Chandra Washington? Yes. Eva Madison? Yes. Robert Dennis? Yes. Suki Hires? Yes. Evelyn Rios Stafford? Willie Lemming?
Yes.
Jim Wilson?
Yes.
Butch Pond?
Yes.
Lance Johnson?
Yes.
Shannon Marty? Sean Simons? Bill Lessery? This ordinance passes.
All righty, item 10 passes. Item 11, Counselor, will you read that one by title only?
Item 11 is an ordinance ratifying a conditional use permit recommended for approval by the Planning and Zoning Board for King's Ransom RV Park.
Again, this ordinance is on its first reading, so again, unless there's a suspension of the rules, it'll just move on to next month. J.P. Deakins?
Thank you, Judge Wood. I've had a lot on my plate this month. I haven't had a chance to follow up on this. I think we all got an email from the Beaver Water District late this afternoon. I'd like to leave this on first reading. Thank you, sir.
All right, we'll move that one on to May's meeting. Item 12 is the Rodgers Springdale Quarry expansion. We'll have this go in phases. So the first phase will be going ahead and having our planning team come and do a presentation. Mr. Crouch, good evening, sir.
Thank you, sir. Bear with me just a moment while I get this loaded up.
So what we'll do is, as he gets that set up, through this process, he'll go ahead and walk through the presentation. After that, I'll invite agencies that may have comments that they would like to make, and then they will come. And then after that, I would ask the Rodgers team to come and visit. And then after that, we'll ask for those who appeal to come and visit. Are you looking there, Nathan? Is it still pulling up?
Yes, sir, that's live.
Okay.
Just a second.
J.P. Deakins?
Sorry to interrupt, but really quickly, do we have any word yet on the live stream? Is it?
It's going.
It's going. Okay, thank you so much.
J.P. Madison.
There's some kind of echo. It's just started with our sound. Is there a way to?
Yeah, Bob, I don't know if you can hear that, but if you can check in, and maybe the volume is high.
Thanks.
Nathan, go ahead.
Yes, sir, just getting to the right slide. It appears to be updating very slow. There we go. Thank you. The Rodgers Springdale Quarry Expansion Conditional Use Permit. At the November 5th, 2020 Planning Board meeting, I presented the CUP request for the Rodgers Springdale Quarry Expansion CUP to the Planning Board, and the board voted to approve the CUP with the condition that I present the updated list of conditions of approval at the December 10th, 2020 meeting. Since then, the CUP request has been tabled for one reason or another, but collaboration has been going on between myself and several attorneys involved with the project, including the Rodgers Group staff attorney, Mrs. Hunt's attorney, the county attorney, Beaver Water District staff attorney, and a couple other attorneys representing various neighbors. Together, we developed the list of conditions of approval that were presented in the staff report and are attached to the end of this presentation. So, the presentation. The Hunt Rodgers Quarry Expansion CUP request is located in the northeast portion of the county, adjacent to the existing Hunt Rodgers Springdale Quarry. The requested expansion area is on company-owned property adjacent to the east side of the existing quarry in Beaver Lake. Here you can see it is adjacent to Beaver Lake and multiple residential developments. In this image, you can see the existing quarry takes access from Parsons Road, which is Washington County Road 91, and the entrance is shown here with a red X. Apologize for the time. The site plan submitted by the project engineer shows the location of the existing quarry in relation to the proposed 152-acre expansion area. Proposal has been revised by removing both of the areas that were to be redesignated from stockpiling to mining to the north of the pit, as well as the addition of 34 acres to the south of the pit for spoil storage and stockpiling. Now the plan calls for the addition of approximately 152 acres of additional mining area to the north and east of the existing pit and roughly 34 acres of stockpiling room along Parsons Road. To be clear, the original quarry was 120 acres. In 2012, 119 acres were added. Today, 186 acres are requested to be added, which includes the already permitted 34 acres that are proposed to change from stockpiling to mining, for a total of 391 acres permitted to mine. This is the site plan with the green area indicating the ADEQ permit area. Sorry. And the yellow area indicating the proposed quarry expansion area. The applicant is in discussions with Northwest Arkansas Land Trust regarding dedicating a permanent conservation easement that would extend along the Beaver Lake shoreline, shown here in green. The intent of the conservation area is to protect the land from future development, therefore protecting water quality, air quality, wildlife, etc. And just today, I received a letter of intent for the conveyance of the conservation easement. Additionally, the applicant is proposing to dedicate the remaining area between the quarry and the Friendship neighborhood, shown here in purple, as a preservation area where development will be restricted. The green lines in the purple area indicate areas where they will plant screening trees of various species and sizes to screen the neighborhood from the quarry, reducing the impact of the light, dust, noise, etc. on the neighbors to the east. The neighbor notification packets went out to all property owners for the properties within 1/2 mile from the existing and proposed subject parcels, including some properties in Benton County. Planning staff has received nearly 200 opposed comments via phone, mail, and email, and received comments in favor as well. Some comments come from outside the 1/2 mile notification area, and there are several neighbors that have commented twice. Also on December 8th, one neighbor submitted a petition of 59 names opposed to this request. This map illustrates where the comments are coming from. All of the shaded properties received a neighbor notification packet, while the properties shaded in red were opposed. Green represents the subject properties. The opposed comments were regarding many aspects of compatibility, such as property value decline, the lifetime of the quarry, environmental concerns regarding the lake, wildlife, drinking water, noise, dust, increased traffic, damage to personal property due to blasting, air pollution, health risks, hours of operation, dump trucks obeying speed limits and driving dangerously. This excerpt from Washington County Future Land Use Plan indicates this area as general commercial, shown here in red, and heavy industrial, shown here with the blue stripes. It's an old computer, y'all. There we go. Okay, we're getting there. So we're stopping back on the site plan. Pursuant to Washington County Code, pursuant to Washington County Zoning Ordinance, Section 11-200, the criteria for allowance of conditional uses. The following criteria must be met to approve a CUP. The objective items numbered 1 through 3, that the application and fees have been submitted, and that the neighbors have been notified of this hearing, and that adequate utilities, roads, drainage, and other public services are or can be made available, have all been satisfied. And the following are the subjective criteria. Number 4, that the proposed use is compatible with the surrounding area. The staff comment on that one, on number 4 from the planning board meeting, was that the existing quarry received CUP approval in 2012 and was considered compatible with the surrounding area at that time with the conditions that were approved. This current quarry expansion request is to increase the area of that existing quarry. Since a quarry already exists at this location, the county's future land use plan indicates this area as heavy industrial. Planning staff feels compatibility has already been discussed and approved. However, many neighbors disagree with the compatibility of the CUP request and are requesting denial. Number 5, that the establishment, maintenance, or operation of the conditional use will not be detrimental to or endanger the public health, safety, morals, comfort, or general welfare. Staff commented, the requested use is already established with the existing quarry. This CUP request is an extension of the existing quarry on adjacent property that was owned by the applicant when the zoning was established in 2006 and was partially being used for quarry operations when the CUP was approved in 2012. Number 6, that the conditional use will not be injurious to the use and enjoyment of other property in the surrounding area for the purposes already permitted, nor substantially diminish and impair property values within the surrounding area. Staff comment, as this request is to expand an established quarry that received CUP approval in 2012, planning staff feels the expansion will not impact the other properties in the surrounding area any more than the existing quarry already does with the proposed conditions of approval. Number 7, that the establishment of the conditional use will not impede the normal and orderly development and improvement of the surrounding area for the uses already permitted in the zone. Staff commented, the conditional use has already been established with the existing quarry, and planning staff feels the expansion will not impede normal and orderly development and improvement of the surrounding areas any differently than the existing quarry has. And then going on, there's a section B which states that the planning board, or this board in this case, may impose additional conditions on this CUP request. And then following this, I just have the conditions of approval. The staff has reviewed the CUP submittal documents and recommends these following conditions of approval. And I'll remind you that these conditions came to us or came about by quite a bit of collaboration between myself and their staff attorneys and Beaver Water District and so on. And so, that's it for my presentation. I'll take any questions you have of me. I apologize, and let me add one more thing. Also, earlier today, Beaver Water District staff attorney got in touch with me, and she sent this email to me, and I think that she sent it to all of you as well, with a bunch of highlighting in there. And it basically just outlines 2 Scrivener's errors in the conditions of approval. And it was brought up at planning board that the Scrivener's errors were in there, and asked that we please correct them. But we had already gotten to a point in the meeting that they wanted to go ahead and vote. And so the staff attorney, Colleen Gaston from Beaver Water District, got in touch with me and asked me to bring that up tonight, that maybe we could get those conditions, 2 conditions, corrected before it's ratified, if that's pleasurable. Thank you.
Do we have any agencies here to also speak and talk about the presentation? And then at that point, I'll let the JPs have any questions of them before we go ahead and bring the applicant up, as well as those who are in appealing. Do we have any agencies here who would like to speak on the project? Okay, have him go ahead. JP Madison. And
Thank you, Judge. You answered one of my questions. I was concerned about the errors that Colleen had mentioned in her email. My second question was the future land use plan.
Yeah.
When was that adopted?
I believe that was adopted with zoning back in 2006.
Okay.
They usually go hand in hand, and I'd have to look. And I believe that it was adopted back then, but I don't stand by that.
Where can we find that?
It's online, and it's in our office on within our system, within our server. I believe that it's on the planning. I was pulling my phone out like I was going to pull it up, but
I'll look. Okay.
on the planning website.
Okay, thanks.
okay, with that, let's go ahead and have the applicant come. You have 30 minutes. Oh, do we have another? I don't see anybody. Okay. So after we give 30 minutes to the applicant to go ahead and share, then we'll go ahead and ask those who appeal to go ahead, and they'll have 30 minutes as well to share.
Can you guys hear me okay?
Absolutely.
All right.
Good evening.
Thank you very much. My name is Andrew Effinger. I'm the Assistant General Counsel of the Rodgers Group. Rodgers Group is the partner with the Hunt folks, and HRM, who is the applicant tonight. We operate that LLC as a joint venture. I'd like to start off by just thanking quite a few people here. As Nathan mentioned, he was involved, Mr. Lester was involved, several of the other attorneys, JP Deacons was involved. This has been a long process, and I think there's been a lot of fruitful conversation, so I just want to start off by thanking those people involved. I have copies of this map that was presented. I think I can just skip to it on this presentation if it's still. I can't remember. See if I can get where I need to go here. I guess, is it not up there anymore? Okay. If anybody would like a copy, I've got. Did we lose it?
Nathan, we're gonna have to upgrade your computer.
Well, let me see if that opens up, and I'll just kind of walk through some of the timeline here. This quarry was opened back in 2003. As was mentioned before, 2006 was the year that the county adopted zoning. So the quarry initially operated under the LSD regulations that predated zoning. In 2012, when the Rodgers Group started having conversations with Hunt about a joint venture here, the the implications of the zoning ordinance that had been passed on top of the LSD regulations that they had complied with left the zoning status unclear. So in 2012, Hunt Rodgers ran this quarry through a conditional use process that came right in front of this board. And rather than that being the expansion that would be the final destination of the quarry, that was merely a compliance effort to make sure that the quarry was then in compliance with the conditional use process. So on the map, you can see that there is the original quarry, there's what we call the 2012 mining area and stockpile area, and then there is the proposed mining, the proposed berm, the proposed stockpile, and the screened area. To begin with, we'd like to continue the berm down along Parsons Road to screen the traveling public from the quarry, just as was required in 2012. We think it makes sense now that the Hunt folks have acquired that property to make that berm continuous and shield the traveling public from it. All right, so we're good. I'm referring here to this green area along Parsons Road. That was excluded in 2012 because we simply didn't have control of that piece of property. The yellow shape you see next to that green berm is going to be additional stockpile area. We will fill that in with gravel and store rock there. It's approximately 29 acres. And then the big request is the 150 acres in red that is the proposed mining area. One thing that I would like to point out to the Quorum Court, you saw those maps earlier that showed the buffers around the parcels that this request is impacting that went well into Benton County and well outside of a half mile around this area here. What Mr. Crouch did in the planning department was to send notifications outside of the parcels that were impacted by this. And some of those parcels that we impact are a lot larger than what we're actually impacting. So this here is the actual impacts of the quarry. The blue area you see shaded, the screened area, is tied to these green lines that you see described as preliminary screens. That area is called out in a condition that requires for us to create vegetative screens, screening the views from the Friendship neighborhood before we ever mine into that area. That'll be relevant if we get into the conversation, which I'm sure we will, about phasing. So that describes the proposal. Let me go through just the responses and some considerations that I think the board needs to consider relative to the impacts of this quarry. First and foremost, as we discussed, this is an approved CUP in 2012 that has conditions on it that already do apply. We have restrictions about tarping trucks, operating under a dust abatement plan, complying with MSHA and ADEC permits. So there are already conditions that apply to this quarry. The expansion into the red area is not an intensification of the impacts of this quarry. This is not an increase in the size of our crusher. This is not an expansion of the equipment. This is simply long-term mine planning to lay out what this pit will be for the life of the mine. We had a lot of back and forth with the neighbors about that concern, and those bigger maps that I mentioned that Nathan put out had people concerned that we were going to go further and further and further, that we were going to mine all the way down to Beaver Lake, that we were going to keep going toward Friendship, and that we were going to go up across Ponderosa Drive. That's why you see the purple area and the green area. We're committing to stay out of those areas, to never mine any further toward Beaver Lake, and to never mine any further toward the Friendship folks. So with all of that said, the conversation today, I think, needs to center around the impacts of this change from the 2012 conditional use permit and the responses that we've had to those changing impacts. Obviously, over the coming decades, blasting will move closer to certain neighborhoods, while the crusher and the main operations and the selling point stays at the same place. That's why we paid particular attention to that area to the east, and that's why we've created the screened area, and that's why we've created the screens. No one wants to sit out on their back porch and see mining equipment running up and down off in the distance. So we're going to avoid that by building those screens for folks. Outside of the visual impacts and the dust and noise that is already approved, there will be no increase in truck traffic. There will be no increase in sales. Our sales are dictated by the local market. We supply concrete plants, we supply asphalt plants, we supply customers who need rock for their driveway. As to the property values, I think you guys probably saw in our packet, we submitted a study that actually includes one of our Rodgers Group quarries, an economic study that was done on 4 quarries around the United States. They could find no correlation between living near a quarry and property values. Other things determine your property values, typically the condition of the property, local market demand. And another thing about property values I do want to bring up is that the Friendship neighborhood might be the only neighborhood in town now who can say, this area out my back porch will always stay like that forever. So there's going to be a commitment for those folks that the views off their back porch are protected. And lastly, I want to hit on one of the major issues that was touched on in the appeal, phasing. I'm sure you guys have gotten some contact from some neighbors that are concerned about the comments that were made back in January about phasing. After that January meeting, we left and understood that we had a lot of work to do with our neighbors. We had some open houses. We began having a neighborhood committee meeting, and we asked what the issues were, and we tried the best we could to address them. Certain members of the neighborhood wanted to be very involved in planning this for us, and I think we even had a mine plan submitted for us that was going to show us every 5 years where we could and couldn't go. But when we really pushed back on the issues with the Planning Commission, the ultimate concern was control, making sure that the rules would stick, they would have teeth, so to speak, and that there would be recourse if something happens that is a violation of one of the conditions. What was suggested was the ombudsman. It was mentioned earlier in public comment. What we've proposed is to have a third-party engineering firm that's going to be chosen between our neighborhood committee and Rodgers Group, who's going to visit with us at our neighborhood committee meetings. They're going to receive public comments. They're also going to regularly review whether we stay inside of these shapes you see on the map, and whether we keep our permits up, and whether we are in violation of any of our permits. And pursuant to this concept, they're going to have recourse to come to Nathan in the planning department, and ultimately, if we're ever so obstinate, they would be in front of you guys. So the idea is to give a communication channel so that if there are issues in the future, we're not complying with a condition for a certain reason, we will get in compliance. I'd also want to make a little bit of a comment about the rules of comment that were mentioned in the appeal. You know, this started pre-pandemic, this proposal did, and I believe the first meeting was in here with the Planning Commission. That quickly was derailed. A lot of what we've done has been by Zoom, and the Planning Commission has done a really good job of trying to deal with those procedural issues in a Zoom setting. We had members participating from their homes. We had members participating sometimes from their car. We had people at home participating in all kinds of various different formats. And yes, sometimes I spoke before they spoke, sometimes they spoke before I spoke, sometimes the public comment was on a timer, sometimes it was not. I think the Planning Commission did the best they could and heard public comment regularly, and heard quite a bit of it. I'd also like to have a note on this technical issue of referring to the conditional use permit as approved in our February meeting. Just to walk the chronology back for you guys. Meeting number 1 was back in January of 2020. Response number 1 to the phasing comments that you have heard and probably have read and probably will hear is that there is phasing in our project. You could refer to the red area that is not in the blue hatched area as phase 1 and the blue hatched area as phase 2. The conditions are structured such that we cannot go into that area until there's appropriate screening to where they can't see us there. Okay, so rather than creating arbitrary this many years, that many years, We built a phased approach based on the real concerns of the neighbors. Also, I'd offer that the concerns about phasing that were raised by the planning board in January a year ago were satisfied as we went through and added that phasing approach and some other conditions. The gentleman who was quoted in the appeal as having phasing concerns ultimately voted for this conditional use permit. So keep that in mind. And ultimately, the comments that he made in the conversations leading up to his affirmative vote spoke about keeping us in check on our boundaries, making sure we keep up with our permits, making sure we comply with the conditions, and to make sure that complaints are heard. And that's what we're targeting this ombudsman condition to take care of. So with all of that said, and I hope that you guys had the opportunity to read the letters that I said that outline some of this in more detail, I'd like to just make a couple comments here on what expansion means for us, and then ask you to support this. It's not uncommon for these kind of issues to arise for us as a mining company. I understand the question that was asked earlier about the community plan and when it was put together and being back in 2006. Most times when zoning comes into an area, the only areas that are shown in a community plan to be mining are the areas where there is a mine, right? You don't normally have a planning department that says, here's where we're going to put limestone mines. It's not usually one of the considerations. And this kind of extraction use is particularly challenging in a land use setting because this is one of the very few industries where the land is our inventory. So typically the idea behind a zoning ordinance is that you give people notice, you let them know what's supposed to go where, and then they can understand it. They can use that information to act. They can buy land in appropriate areas if they want to do X or Y. But when zoning comes in around a quarry, as you're seeing here today, the only thing that's zoned for quarrying initially is where the quarry is. Well, a quarry that can't grow can't exist in the long term, right? So there's a particular takings type legal issue here with land use and quarries. We've chosen to comply back in 2012. We've chosen to comply here in 2020 to come to you guys, show you the plan, show you how we can mitigate the impacts, be good corporate citizens. But an interesting thought experiment would be to think about this as our inventory and then think about some of the other conditional use permits that you approve. It wouldn't occur to you guys to place a condition on the brewery that they can only buy so many hops a year. Right? It wouldn't occur to you to say to the RV park, you can only have 5 RV spots now and then 10 more. If you want any more than those, you have to come back to us when they've laid out their plan. This is our plan for this quarry, for this market, to serve this area, to serve the citizens and the businesses in this area. So when you hear concerns about phasing and not so much, and this is a big plan, this is the inventory of our business. And we're trying to run a business responsibly. We're trying to run it in this community in the right way, treat our neighbors fairly. And we're here, and we've gone through a very long process, 13 months now, to do that in the right way. So I'd ask for you guys to consider all of that, especially the Hunt folks with some of this property to the east. You know, we've given up the right to commercial or industrial or any kind of, or even residential development on over 200 acres of land in exchange for the rights to mine 150 acres of land. So I guess with all of that said, we'd like to politely ask that you guys ratify this conditional use permit for us. And with that, I'll close and we can move on to the public comment or to hear the appeal.
With that, thank you very much. We're going to go ahead and, for those who are here to appeal, or who have filed the appeal, have some opposition to the project, we're going to go ahead and give you guys 30 minutes to address those concerns.
But anyway, he spent that time because it was a Zoom meeting and it was right after we finally get back to some kind of normal. And this is, by the way, very unusual for me. So you see people in person and be here live, but I appreciate that. Anyway, if you look at that meeting, you can see that it's not like it's willy-nilly. We did it this way one time, we did it the other way. You guys know what rules are in meetings. And we feel like we were at a definite disadvantage because we basically had 11 months go by. Now we're showing back up to hear this proposal again, wondering what they've done. Because they were sent away with very clear instructions in that January meeting to bring back a phased approach to this mine expansion. And during that time, we were expecting to see that, but, we didn't know what to expect, but we had to comment first. So we laid out what we thought we knew, which wasn't anything accurate, because at the end of the day, when they came and actually presented, it was like invisible ink. The map that they'd showed in January had clear phasing lines on it. And the map they showed now is just like it is now, except the one that they showed with 2 phasing lines now, but the one before that, there was no phasing lines, so no phasing. But we really feel like, these rules of order are put in place for a reason. And typically what happens, in my experience with rules of order, is that when something goes amiss, just like point of order here we've heard tonight, it's addressed immediately. But this has been left unresolved, unquestioned, and it's just allowed to proceed. In my opinion, since the rules were not followed in their own rules of conduct, that not only should that meeting, the discussion, and anything that was voted on be vacated, but all other meetings after that should be vacated, and we should go back and revisit this proposal from the very beginning with the 3 new board members that just got on the board and start from scratch as far as looking at what the proposal is. My second ground of appeal, gotta make sure it's doing it right, sorry. My second ground of appeal is really on merit. So, just to set it up, and I heard Nathan, and I didn't get the number down, but it had increased even more. I think it was like 130 people opposed this current, that he said, this current application. But before the January 23rd, 2020 meeting, we had, and he reported this, 113 neighbors had responded in writing in opposition to the expansion of this quarry. Over 100 neighbors showed up in person. This room, there was no social distancing in this room. And many of our neighbors chose to speak that night with passion about the things that they were passionate about and wanted the planning board to hear and consider. From that, what happened was that the planning board was, one, taken aback by the vast amount of opposition to this, and I think the Rodgers group was caught totally off guard because they thought they were going to come in and get a rubber stamp. But they carefully considered all our comments, and I have to say, our comments were heard. And they sent the Rodgers group away with a mission. And we'll get into the actual details because I think it's very important that you understand the conversation that took place. But they were sent away and they were asked to actually bring back a phased plan, and we'll have details on that. So during that meeting, I know it's been referenced many times, it was referenced here tonight, 2 or 3 times, that it was passed, the cup was passed. I reached out to Mr. Lester and got his opinion on that, and this letter clearly states they passed nothing. So when they represent to new members of the planning board that this was passed, it really wasn't passed. They should have gone back and looked at this again and really considered it. And I have to say, the new planning board members really asked some great questions. It's just that they were already set up. This is passed, you just need to rubber stamp it, move on. I can tell you right now, and he referenced a number, it continues to grow. This is 76 signed people that have not revoked their opposition, but grown their opposition to this. And I'll leave this with the court so you guys can look at it. But, there are still people, including myself, opposed to this expansion. And I can tell you the resounding thing from the inception of this quarry, when the public actually found out about it and started hearing about it and diving in, and in 2012, looking at those minutes, this quarry is not, has not, and probably will never receive the Good Neighbor Award. They're just not. And I guess I have to be the guy that says, hey, here's the elephant in the room. We're talking about 50 years. What other industry, you talk about limiting hops for a brewery, which is not a comparable example, but what other industry can you go into and go, I want to operate for 50 years with impunity? There isn't any, except mining. So I'm calling that out right now. This is a unique situation. We're talking about a huge expansion over a huge amount of time. What's Washington County going to look like in 5 years? I know it's changed. I've been here 17 years, and I've been in the area for probably 30 years because I lived in Springfield, Missouri, and traveled this area. And I can tell you the difference today from then, there's no comparison. If anybody has driven the old logging road down to Fort Smith instead of 540 out there, you know what I'm talking about. There's been progress, folks, and we're not here to stand in the way of progress. We're just acknowledging that 50 years, come on, 50 years? That's a vast amount of time, and we're talking a vast amount of land. Here's where I wanted to dive in and just bring you up to speed on the actual comments during that January 23rd meeting. So, as I said, we had one, Phil Humbert, that took the lead on this, and he just voiced his concern. This is a vast amount of new ground that you guys want to mine. This is going to be going on for a long, long time. And, he's just really not comfortable. And then Robert Daugherty spoke up and said, I'd be more comfortable if this was done in phases. This was done in phases because they pointed out they're not a good neighbor. They said it straight to their face. You guys are not a good neighbor. Obviously, all the opposition, they're here for a reason. You haven't engaged them. You're not a good neighbor. We need to have some kind of way that you have to come back so we can see that you really are a good neighbor. Now, guys, I know that you have, in this Quorum Court, had several mining operations come in here, and there's one thing that, is kind of common amongst all of them is they don't always play by the rules. So, and we'll hear and have heard many times that the Hunt Rodgers group is almost lily white, and I have some evidence for that too. But moving on from that, and the conversation came back to Phil again. He's talking about phasing, and it came to Tim Gorman, and he said, "So the request is what?" And here it is, guys. Here's what they were sent away with. Very clear. Is to have something definite. That is the phase. We are not going to go past this line until we get approval for the next line that we're going to do. It can't be any clearer than that. Let's fast forward November 5th. We show up. We have to present first. They come up. No phasing. Nothing. Zero. Now, I know we've all been in school, some of us longer than others, but if I had a book report and I turned it in and my teacher said, no, take this back, do some work on it. I brought it back and didn't do anything on it, what do you think I'd get? An F. I'd get an F. So they didn't do their due diligence. I don't think we should be rewarding them for ignoring the planning board's request. I really don't. I don't think we should be rewarding them. This is a vast amount of land, over 50 years. It's a long-term project. We don't have a detailed phase program. I can tell you, just like I will demonstrate in a minute, what they've done in the past, they will mine at will. They will do whatever they want. The enforcement's not there. You mentioned the planning board. The planning board's not an enforcement agency. An ombudsman, he's not an enforcement agency. They'll get complaints, but it's up to them to voluntarily comply. And I'll show you an example here where they weren't in compliance. And every time the answer's the same. We're sorry, we'll do better, try to do better next time. So we hear the same thing over and over. I think if they were really concerned about their neighbors and really wanted to, have peace of mind for the neighbors and themselves, they would conduct blast surveys on the houses within that half-mile region. The attorney said here, Mr. Effinger, said, we will do that. Guess what's not in the conditions? Blast surveys. So this is the kind of thing, it's like, we're gonna show you this nice shiny watch that's perfect, 24 karat gold, but we're gonna give you a box of gears. And you gotta figure out how to put that together to get that watch. So, they say a lot of things, they said a lot of things tonight, but their words don't match their actions many, many times. Finally, we've got one gentleman in our neighborhood who's retired military. He is very, very detail-oriented, and I know he sent you guys an email, and it contains in that very detailed information. So we asked many, many times from the quarry, and they said they had it. They don't share it, not transparent. It's like, how much material do you have? How long do you think it's gonna, at your current rate or at accelerated rate, how long do you think you'll mine in this particular area or that particular area? Well, guess what? This retired military veteran, he retired as an investigator. So he is very detail-oriented, and he can get to the bottom of this. So since it wasn't shared with us what the quarry was actually gonna mine and pull out of the ground, he did this work. I didn't do anything. I'm just telling you, if you looked at the email, it's mind-numbing. So I'm trying to distill it down here for you a little bit. This is the original map with the phasings. So there's your phasings. Where'd they go? Well, they're here. We have it because we captured it. But what he did on the right-hand side, your right-hand side up there, the scope, currently we feel like with their current rate of production, they have about additional 5.4 years. And if you expand into Area 1, which is straight up, you can see that's about another 5.7 years, and then Area 2 is 11.2 years, and Area 3 is another 11.2 years, with a total of 33.5 years. That's a lot of mining. What we asked is that we're willing to give you guys carte blanche, 1, 2, 3. Go mine your hearts out. When you get ready, about 10 years out, come back. Come back to the planning board. Let's see if you've been good stewards. Let's see if you've been good neighbors. Let's see if you've been in compliance. And then get reapproved for 4 and 5. What's so important about 4 and 5? Currently, we're 15 football fields away from where the mine is today. If they mine 4 and 5, we're 5 football fields away. So they talk a lot about the screening. That's fantastic. They talk about setting aside. Let me tell you, if you're sitting off the back of your porch, you will see the mine. What we're talking about here is not a brewery with hops. We're talking about somebody that's digging a crater in the earth that's going to be there forever. So this is our proposal, that they do what the planning board asked and do a phased approach and come back and get reapproval. We're not trying to stop progress here. During my conversations with, in particular, one of you, I was asked, and I don't think they knew that they were asking me, but they said, we heard that some people bought up the last lots in here, and for God's green earth, why would somebody buy property, build a house next to a mine? And I'm that person. So I just wanted to give you my personal history with this property, with the Hunt Lakeside Estates, and the mine that has also the Hunt's name on it. So in 2003, we purchased a lot and moved over here from Springfield to support a little customer up in Northwest Arkansas in Bentonville, Walmart, so love to work for them. But anyway, there was no disclosure about any mine or anything, and I know the mine, was probably in progress, but we didn't get any disclosure from the real estate agent who was the agent for the Hunts selling a property. About September, we were about 2/3 the way done with the house, came up from 412 up the big hill where the quarry's entrance is, and nothing was there, of course, except for like 5 or 6 guys and 2 pickup trucks out in the field with a stake in the ground, and about a week later, they started stripping the red dirt off of it. Welcome to the quarry. So in 2012, they said that, there was opposition. I think at that time, Nathan said they sent out 57 notices. Well, I can tell you there's a lot more than 57 houses out there then, and there is now, of course. But anyway, just conveniently, no one on Friendship View Drive received a notice of that meeting. No one, not a single person. So I can tell you that I sold my house, and they've done their 3 surveys, and they've done another one of their quarries about property values. Well, I'm the guy that built the house right next door to his old house. So for a survey of 1, I can tell you that my property sold for about $20,000 less than the market rate. Yes, it sold. I'm glad it sold. Glad to be moved next door, and we have fantastic neighbors. And hopefully we'll be there for a long, long time. But we spent the time and built our house in 2019. But in the process of that, we purchased 2 lots. We purchased the first lot directly from Mrs. Hunt and Catherine, her assistant, in her office. No disclosure about a quarry. Didn't really expect any because we knew the quarry was there. What we didn't know is the plan to expand the quarry. And then we purchased another one next year in 2016. And, at that time, I think they probably knew they were going to expand. But again, there was no disclosure about the quarry or an expansion or anything like that. And then we built our house, and then we get notice that there's going to be this huge expansion. So here we are. So, unfortunately, I've talked to all the neighbors in the neighborhood. There were no disclosures on the quarry when they bought their lots. I don't know how that happens, but it did. So here we are. One of the things that you will hear the quarry or the Hunt Rodgers group say, and they've said it many times, they said it at the last meeting, they did not say it tonight, but they do say often that we're here to shut them down. And I can tell you that from the words of, I'm sure there's some that would like for them to shut down, but from the words of people who represent the neighbors in the neighborhood, that has never crossed our lips. We're not standing in the way of progress. We're trying to get accountability and slowing them down and having them actually do what they said they're going to do. That's our process. That's our purpose here, is to really just slow the roll. You let them be a good neighbor. Let them perform. Let's see how they do. Because here's how they perform so far. These are facts, folks. This is public record. I'm no investigator, but Mike is. And just a cursory look, we found this information. So at 6/12, in 2012, the quarry operated outside of their permitted area, actively mining outside of their permitted area and stockpiling. I think this is pretty common practice with quarries. 6/12 also, they said, as part of the sale, I'm a salesman, I sell wax, so I know all about the pitch. We got the pitch tonight. They said on 6/12 that part of getting the stockpile area, that they could run that crusher for maybe 6 or 7 months out of the year, and they wouldn't have to run it anymore. Guess what? They're running it 12 months out of the year, and a lot of days they're running it 24 hours a day. 6/22/18, the quarry operated with an expired permit. Things happen. In 2012, as a condition of that planning board meeting, they were tasked with planting a vegetative barrier on the berm. They did. It died. They never replaced it. Words don't match action. We don't think they're trustworthy. That's why we're asking for a phased approach. Let's move on. They tell you that they're in compliance, that they're great stewards of the environment. Well, just this last year, in 213 and 220, ADQ noted violations. Now, due to the pandemic, they weren't notified of these violations till May. So what happened between then and that time, who knows? It's fine to say that you're regulated and that you have all these things that you got to do, but don't tell me that your employees are safe because OSHA covers that. Yeah, you're going to make your employees safe. They're going to have hearing protection. They're going to have dust masks. They're going to have probably hard hats in some cases, eye protection. Neighbors don't have that, so that's not comparable.
This particular example here, this discharge went into Friendship Creek, which when you show that, that flows right into Beaver Lake. So they were tasked with cleaning this up. They made the changes, but I'm just pointing this out. They do violate. They're not in full compliance. Let's talk about that neighborhood committee. So yes, after the meeting, guess what? They did reach out to the neighborhoods, and they did have open houses, and they did invite us in. And I did go to that meeting, 1 or 2, 3, 4. I haven't been to one since COVID hit really bad. But when I was there, they said, anybody that wants to be on the neighborhood committee, give us your information, we'll put you on it. I gave them all my information. I never received a contact. I'm not a bad guy. I mean, I'm a wax salesman. I'm not hard to talk to. So, but anyway, I did contact the Quarry again. I was informed that it's full. The disconcerting thing here, folks, is that the neighborhood committee, apparently it doesn't belong to the neighborhood. We were informed that the Quarry wants to tell us who is going to be on this committee and meet with them. Hours of operation, let's talk about that. So one of our main concerns has been the hours of operation, and it's still a concern for us. These guys operate 24 hours a day, and I can tell you, they will tell you that half the way to Friendship, you can hardly hear it, and when you get it to Friendship, it sounds like a refrigerator. This is no refrigerator. This is loud. It depends on what they're crushing at night, but sometimes they crush stuff that it wakes up the neighbors. And we have a lot of small children in our subdivision, I'm sure around the area, but this stuff goes on all night long, loud, very loud. So, here recently after the last meeting, I don't know what they were doing. I mean, it was horrific. And some people actually tried to file a complaint. I know the lady said, you can do it on DEQ. You can't. So we had some people call in. Turns out that there is no noise ordinance in Washington County. Maybe we could get a noise ordinance going, but there is not a noise ordinance in Washington County. So our only recourse is to ask you all to, force some kind of regulation where they would have to shut down. I mean, we're not opposed to progress, but we would like to have our evenings quiet. And I think we got a glimpse of the future at the last meeting. And this is really our concern and our fear. And at the last meeting, Andrew Effinger, on 226, he was addressing the planning board, and quote, he said, "We currently have a conditional use permit approved by the Quorum Court to run without any hour of operation limitations." Wow. Not only that, I would ask each of you to go to the minutes or the video, actually it's the video because the minutes aren't up yet, and watch what was said during that. It was not pleasant. And actually one of the planning board members said, despite the comments from the Rodgers attorney, I recommend we approve this, despite. It was that bad. As an applicant, and they are an applicant, HR Group is very arrogant, they're condescending, and they will, in my opinion, act with impunity and do whatever they want to do if you agree to approve this cup for the entire area of land they want to mine. We're not unreasonable. We just seek some transparency from the mine, just a simple fact. If you know which direction you're going and how much material, why not share it? Maybe that's their plan with the committee. I don't know. Can't speak for them. I really would like to see them come into compliance with what the planning board originally asked for, that phased approach, and have that hard stop. Give them 1, 2, 3, but on 4, let's have a conversation. Let's not have an ombudsman. I don't care about an ombudsman. If we just have them stop at 1, 2, 3, we'll have the conversation. We won't need the ombudsman. Get them to commit to being a good neighbor. Do more than just listening to us. Actually take some action. deliver that expansion plan, and then, put in that vegetation barrier and let it grow up. So we've heard barrier, there's no details around that. I've heard 40 years, or 20 years of growth. I've heard 10-inch diameter. I mean, it's not a hard stop for them. They will be over there in that area, I will guarantee you, if you approve to let them mine the entire area. And then finally, if that's the route that you go, for them to strictly follow that plan. Now, I have pretty good oversight of the area that they mine, because 3 of my neighbors actually overlook the area that they should not be mining in. And with that, I will thank you for your time and your consideration, and hopefully, your conscience will vote your conscience. Thank you.
Okay, with that, we will now go into our conversation with the court. So if you have comments or questions for either the applicants, let's see, Rodgers, you guys want to come back up, and we'll go ahead and turn the mics on for JP's. Say it again. Who? Come on, you go ahead and say it. JP Dennis, go ahead.
Thank you, Judge. I appreciate it. Mr. Evinger, I would like to thank you for providing essential products for our building industry. My district's number 10, and Farmington and West Fayetteville, and I think that we're probably the fastest growing district there is. So we thank you for all the products that you do provide for us, and economically it's been great. It's helped a lot. I would like to ask this though. I'm a common sense type guy, but I'm also a compromiser, and I'm looking for a compromise. Would you be able to compromise and mine from 1, 2, and 3, and not 4 and 5 until the 1, 2, and 3 run out? And with that compromise, also, could you suspend gravel crushing between 9 p.m. and 6 a.m.? Thank you.
Okay. Before I answer that question, I'd like to just give a little background on both of those points.
Okay.
Phase 1, 2, and 3 are essentially the same area as the mining area I showed on the map that is excluded from the screening area. The screens that we've designed are built specifically for protecting the impacts of that area, the screened area, before we go into that screened area. So for all intents and purposes, we have agreed that 1, 2, 3 is mineable without screening for the neighbors, and then phases 4 and 5 must wait until we've appropriately screened the neighbors' views. And the commitment we've made is to work with a landscape architect or some kind of certified professional to build those appropriately. You heard some of the commentary that talked about the size of the trees and all that. We're not trying to be the experts on how to build those trees. The condition is that the screens need to be in, and they need to be screening that area before we go in there. So we feel like we've essentially complied with that. The hours of operation, one thing that I think it's important to consider in this whole conversation is we went through meeting after meeting after meeting, talked through 47 different conditions. And what we had was different factions asking for different things. Okay, a good example is the conservation easement and the preservation area. Beaver Water District wanted all of that to be a conservation area. Some of the neighbors didn't want Beaver Water District and the Northwest Arkansas Land Trust involved. They wanted it to be just directly a commitment from us to them. Okay, so we had to split some babies in certain scenarios. As to the hours of operation, there are times when we run our facility, especially in colder temperatures, where we must circulate water to keep the dust down. That's the solution to the dust problem. You spray a fine mist and the dust doesn't blow off into the air as far. Captures the dust. In the cold weather, we need to be able to run that plant and not let those water lines freeze every night. So that's an operational concern for us. We heard the requests about the operations, the hours of operations. We heard from some folks who wanted their weekends. We heard from other folks who wanted their weeknights. We established the condition that we established. Friday nights are yours, Saturdays are yours, Sundays are yours. But Monday through Friday afternoon, we do have the ability to run through the night. That was the concession that we made early on in the process. I want to say that was at the November meeting, if not prior. After the December meeting, we had 4 different Zoom meetings with a collection of attorneys, myself, JP Deacons, the Beaver Water District folks, and some representatives of different neighbors. We discussed all of the conditions, some of them over and over and over again. And then we finally said, we think we're done here. And then just a few hours after that last meeting, I get an email from one of the participants that says, I don't think they should be allowed to run after 9 p.m. during the week. That's after we've stacked hands on everything, after we've given a concession on the hours of operation in one direction. So what I feel like is going on here, and this is what I said, and I apologize to everyone involved if I got a little bit heated in that planning board meeting. There have been people involved in this process who have stuck with us, who've negotiated in good faith, and we've made some really good progress. And then there have been some other folks who wanted to wait until the time was right to bring up some issue that they never mentioned before. And for us to go through this year-long plus process and to watch that happen with certain folks doesn't really feel like good faith negotiation. So we've tried to put a package together that a majority of people could stack hands on. You heard the gentleman talk about the 113 people that were there opposed last January. Last November at meeting 2, there were 10 people there opposed. The majority of the public angst about this project from last January was calmed down by us explaining what was really going on, explaining that they had notified a whole bunch of people that weren't really that close to what we were going to try to do, and the conditions that we applied. So politely, with all of that background, we'd like to get a vote on the package that we put together.
Discussion. Go ahead, Jimmy.
Additional question then.
Sure.
How many years could you stay on 1, 2, and 3 before you move over? And I understand inventory.
Yeah.
You know, I said, you know, my district is using so much of it that you have to keep producing because we consume so much.
Yeah,
But do you have
nobody
any
in 2003 would have.
estimates? Do you have any estimates how many years you could wait?
The best idea I can give you guys about a general estimate is that we're trying to set this quarry up for the next generation of operation, okay? Nobody in 2003 would have ever foreseen this pit being as big as it is now, I don't think, right? And nobody in 2012 probably would have perceived that you were gonna have the growth you were gonna have between 2012 and 2021. So what we're trying to do here is look at this site, the property that we own and control. When you hear some of the opposition talking about this vast land grab, this is the Hunt's land, right? We've owned this land for a long time. The idea here is to just lay it all on the table. This is the development of this mine, okay? Whether it's 30 or 50 years is gonna depend on all kinds of things that we can't really project, but it's decades.
Discussion.
You're welcome.
JP Deacons.
Thank you, Judge Wood. Welcome back, Mr. Effinger. I'm glad to see you back again.
Good to see you again.
There's a couple things that I want to clarify. I was involved in the put together of these conditions. I would never call them perfect, and I think they were always open for additional input, and I think I represented that very well when I was involved with them. A couple things too. I don't know that. I am also interested in the hours of operations being revisited, and I know I've heard your explanation about that in that background several times. I have never talked to anybody yet out in the neighborhoods that asked for or agreed to these particular hours. And I think even if the general premise is there, they need to be buttoned down a little bit. I mean, I think the exact wording is you quit Friday at 5 and Saturday at noon, there's no real startup time in there. You know what I mean? I don't know when you can start on Saturday morning or whatever. So, I mean, I think there's some cleanup regardless of where we're at that needs to be done in that language. But I have some contextual questions because I think that's extremely important when we consider this. And Mr. Goff pointed this out in his presentation. The mine was outside of a permitted area in 2012. And I will give the mine credit. It self-reported that. But it was outside its permitting. It was essentially in violation at that time. It wasn't like you guys just came in and voluntarily went under a CUP consideration. Would you agree with that? Am I mischaracterizing that?
Well, I think you're leaving one part out that maybe I need to remind you about. Rodgers Group, doing its due diligence in constructing the JV, started asking questions.
Sure.
And we couldn't get clear answers because of what had happened in 2003 and then what had happened with the 2006 zoning. So the zoning had gone in place since the 2003. So the question on the table about whether we did or did not end up in violation was really an interpretation issue of how you treat this kind of use in land use context. And that, to go back to what I mentioned a little bit earlier, this is sort of a complicated issue in the law because there are some Supreme Court cases in certain states that have said things like, you can't approve a baby elephant, but then not approve a full-grown elephant, right?
Yeah.
So in some circumstances, courts have found that when a parcel is approved to be a mine, a parcel is approved to be a mine. Washington County took a more aggressive approach and said, inside of these parcels, we're gonna draw lines on the ground and you can't go past them, right?
Sure.
And I will point out that the places where we went over those lines were within the boundaries of 2003, 2006 technical interpretation of the average mining foreman. You know, nowadays we can look at things on a map, we can see exactly where a property line is, and we can make sure as we see those images updated, how close we're getting to that. That stuff didn't exist 10 years ago. We've put a system in internally at Rodgers Group to keep track of these things. So now we can sit here with this map that we've designed and say with absolute confidence, you're not gonna see us go across these boundaries because now our managers out there can see themselves on their cell phone and see those lines on their cell phone next to it,
Right.
right? That didn't exist at the time. So yes, we went something like 30 foot over a boundary in a certain direction. It
Well,
wasn't-
I don't know it was 30 foot. It was quite large.
maybe
And what I'm trying to say is what's semantical for you is important for the neighbors because they've bought in to the system. Now, if the system is flawed, it is what they've bought into and what they've expected, that there is some sort of oversight or some sort of protections for them. And I think the problem I'm having is I don't know that there has been. You know what I mean? So that it's a system issue.
Well, regardless of the distance of the buffer, there was 120 acres approved and the additional approval was 13.
Gotcha.
Okay, so we didn't go mine another 40 acres. And when I say we, the quarry prior to the 2012 era.
I appreciate that. As part of that expansion at that time, you guys were, you may have voluntarily constructed the berms, but you were required to construct them, whatever. But on top of those, you were required to put vegetation there.
Yes.
Do you think that vegetation was adequate in its design?
Well, I think a little bit of hindsight bias going on here, but no,
Right.
it failed.
But what I'm not even talking about its failure. I'm talking about in its design. Those trees are how many feet apart? And go ahead.
If I would, to me, the ultimate design of a berm or a tree for screening depends on what you're trying to block the view of.
Sure.
Along North Parsons, there's some areas where you can't see anything but blue sky over that berm. So in those situations, I'm not sure why we put trees there, right? The trees are for kind of an aesthetic, nice look in front of the berm, so you're not seeing an ugly big hill of green grass. So I can understand adding them just for aesthetics,
Yeah.
but it isn't as if when you're on North Parson that there's some big structure we're trying to hide.
Right.
That makes them different than these screens on the east side where
Yeah.
we're trying to make sure people can't see us.
And what I'm saying is, I don't think that design was ever adequate to screen anything. I mean, they were so far apart that what I'm saying is, even if the trees would have survived and matured, they were never close enough to do anything of substance. for
Agreed,
the
but I don't think anybody designed them to
Gotcha.
do additional screening because there's nothing behind there to hide. It was simply for aesthetic purposes to make it look more natural.
Well, the CUP stated it was for screening. And I want to note that you guys have went out on those berms, and this would be on, for reference for the other justices, this is on that west side that's butts up against Sonora, and you guys have planted what I think from I'm not an arborist, but it seems like a much more well-thought-out design of those, and I do appreciate that. It looks like that now, that plan will be more screened when it
Yes.
matures. I mean, it will be what I thought the original intent was in 2012.
Absolutely, and I think this is one of the things we need to consider when we talk about what I mentioned earlier about drawing the lines and being very careful about the zoning, the way the planning board has here in the past, the planning staff, I should say. We've owned that piece of property now for a while where we're asking to build this berm. That berm could have been there. Those trees could have been there. We're asking for permission now to do that because this is the way the zoning ordinance works in this area.
Sure.
So we're trying to get that berm
Yeah.
built, and we're
Right.
needing permission to do it, right? And when we planted those trees, they died. We planted them again pursuant to the plan, they died. Nobody really knows whether the engineer put that plan together or whether that came from the county. You know, we're not in the business of designing tree planting plans ourselves. But as soon as that was brought up and everybody said, yeah, you know, there was a significant turnover here in 2016 in the planning staff. And so the people that were intimately involved in it were no longer here. And so we decided, okay, let's fix this. And that's what we did. We got somebody involved. We got an arborist. We had somebody that knows what they're doing, tell us what we ought to do, and we put them to work. And that is the plan on the screens on the other side. We want nobody to be able to see this area. Fill in the blank professional, tell us what to do, and we're gonna do it.
Great. I've never, I'm buckled in. There was a large dirt pile, almost a mountain. It was huge. It was
Yes.
red. What was that? Because you guys have since making this application, taken that dirt pile down. I mean, that dirt pile was visible for miles, right?
Yes, yes. This is gonna be hard to believe, but from where we sat in our facility, it wasn't really apparent to us that people could see that so far away. And when that came up in our public meetings, we put ourselves to getting that pile taken down. Some of the dirt that's on top of the rock we mine can be sold. You guys, I'm sure, have heard of red dirt pits, right? So some of what we take off on top of our rock can be sold. Some of it can't. It's just dirt that nobody has any good market use for. That's what that was. Call it strippings, call it overburden, waste, whatever you want to call it. It's easier for us from a logistics standpoint to put all that stuff in one place while we're working, and that's where we were putting it. And it seems when you're at the quarry, way off back in the back where nobody can see it, and it is when you're at the quarry, but then, you know, once we started talking a little bit more to our neighbors, it was creating an eyesore. And that ultimately is one of the big issues that brought us to these screening, because not only can you see that big mountain, but you can see that whole ridge line.
Yeah.
And that's what we're trying to shield with the trees.
Backup alarms. Those were audible from the neighborhood for years.
Mm-hmm.
You guys have since replaced those with some white noise technology or something, right?
Yeah,
Is that correct?
Yeah, again, I don't know if you guys are familiar with this. There's a white noise backup alarm that kind of sounds almost like a cricket or some kind of animal.
Yeah.
It's really noticeable, but it's not that high-pitched, ear-piercing backup alarm that people are used to. So once we heard that people could hear those from their vicinity, then we replaced those.
You guys are required to keep as much as you can the dust off the public road, is that correct?
Yeah, that's part of our dust abatement plan that's been approved since 2012.
And one of the strategies you use is a water truck that waters the entrance.
Yes, along with a truck wheel wash.
Wheel wash.
Yeah.
I'm speaking specifically about the water
Okay,
water truck.
Water truck,
right?
yeah.
Has that been consistently done from your point of view over the years? Would you say it was consistently done?
Could I say with any confidence? No, I'm the attorney from Nashville. I haven't been out there watching the roads. I've heard people say that we don't. I've heard people say that we do, and I'm sure from time to time we've done a good job, and from time to time it's gotten lax, I'm sure.
Well, for whatever my character and truth speaks, it has never consistently been done.
Okay.
Okay. The wheel washing system,
Yes.
has it been consistently implemented and used?
Part of this proposal is to implement a new wheel wash system.
Mm-hmm.
One thing to remember in the context of the wheel wash system is we have the same level of control over our truck drivers as a Walmart has of their customers, right? So do people pull around the wheel wash system because they don't want to get their truck wet? Yes. Do we tell them not to? Yes. Do we have conversations with their bosses, and have we banned people from the site because they consistently do things wrong? Yes. That's one of the roles that we see for this ombudsman. One of the struggles we have from time to time is people will see a truck do something silly. They'll call the scale house, and the person who answers the phone is busy ticketing trucks, and that person doesn't get the customer service experience that they deserve, right? And so that's what we're hoping is as these things become larger issues and as we have a neighborhood committee, anybody who sees something like that will have a committee member to go to, and that committee will have an ombudsman to talk to about doing some kind of a review or to watch the trucks for a while or something along those lines. And if we see people that are out of compliance and aren't behaving correctly, we're more than willing to help get them in compliance.
But your position is that the wheel washing system has always been available, up and running and functioning consistently throughout time.
As far as I know.
Gotcha. Does Hunt Rodgers control the neighborhood committee that's been established?
Does Hunt Rodgers control the neighborhood committee?
Yes. You've selected the members, correct?
We've invited people to the committee. I heard Mr. Goss comment that he hasn't gotten a reply back. Quite honestly, the reason he might not have got a reply back is because of the appeal, to be quite frank right now. If there's somebody on the committee that would like to be replaced by Mr. Goss, we don't want to turn the committee into the whole neighborhood, right? We're not trying to be unreasonable about who is and who wasn't on there.
Right.
We do have some committee members that were at the last meeting arguing against us.
Oh, sure. I mean, that's, you
Yeah,
take a
and-
selection, a handful of statistically out there, you're going to get people that are against you. I mean,
Yeah,
that's
yeah.
kind of the point of the committee. I
Yeah,
think.
and that's, I use that as an example of our openness to certain folks. We're allowing them on the committee, we're hearing their voices, and they're still coming and saying no and suggesting the planning board to vote no. And the planning board still approved the package.
But it's been my experience through email with Mr. Gabbard, maybe, that his position is the mine controls who's on the committee, and the mine selects those individuals, and the mine will maintain that selection. And my position is, there's no way that that could be reasonable to anyone. I mean, the neighborhood committee is going to have to self-select and self-administer itself to be free from the influence of the mine. I mean, and we need to work on that, correct? Because
True, I guess in this context, we had a very long conversation about who picks the ombudsman, right? And the same
and let
rules
me
could
tell
apply.
I can't think of everything.
I know.
And it was after our meetings that I hear through the grapevine that there is a neighborhood committee meeting. And I mean, I don't know anything about it, but I'm not on the neighborhood committee, and I don't expect to be on the neighborhood committee. But through that conversation, then I realized I've never thought of the fact that the mine thinks they control this committee and is going to control the membership and the participation in it. So that's what I'm saying. This is a new development since we went through this long list of
And
conditions
that's
that we
fine.
need to continue.
Where I was
working.
going with that is just like we established some criteria for selecting the ombudsman, if you want certain
Absolutely.
people to have control, that's fine. But what I would like to remind everyone is that the impact of this quarry is not just on Friendship neighborhood, right? There are other folks out there, so I don't want it to be, Friendship obviously is the biggest impacted area.
Oh,
right?
certainly.
So
I mean, I think.
I don't even know that we have.
I don't know that neighborhood committee is an appropriate name for it. It's just something that we've all, I think, coined. But,
Yeah,
I mean, I don't
yeah.
think it's restricted to that one neighborhood or in that one area or whatever.
Yeah.
What I'm saying is these questions are why we need to get that spelled out.
Yeah, and I'm open to any further conversation about this here and any conditions you guys want to apply to this approval. But remember that neighborhood committee, we've actually kicked around a charter. That neighborhood committee is something that is going to be started upon the approval of this CUP, right? So what we're doing right now isn't exactly the thing that's going to be happening. There's going to be an ombudsman there, and it's going to be the formal committee meeting that has to meet as frequently as the conditions say. And there's going to be a process of creating some kind of a charter for that meeting. So some of that is sort of to be determined, and the neighbors are going to be involved in it.
Well, your clarification's helping me out because that's not what I was told and that's not what I understood about it.
Well-
and so I think it's going to be a good thing. And I will say this too. The function of the neighborhood committee is going to be like a church. It is only going to be as good as the citizens make it. And I want to tell everybody that right now. I mean, it's only going to be as good as they participate and become a part of it. And that's on them, and I completely understand that. Rodgers Group's the managing partner of the joint venture, is that correct?
Yeah.
So you guys have the operational control of the entity.
Mhm.
Okay. Mike Butler, Greg Goff mentioned him.
Yes.
The guy seems extremely knowledgeable. He seems to also have a lot of time, so he's a resource. And I think he sent us all what I've coined the Butler report. I think he sent that to you guys in an email, but he had a couple criticisms in there about some of your data.
Okay.
And that was like essentially that some of your blast studies and stuff like that the results were given, but the conditions weren't. Do you think that's a fair criticism? Could that be offered? You know, I mean, listen, this is way over my head, but he's talking about the cloud cover, the atmospheric conditions,
Yes.
the wind direction, all that. So what he's saying is we can't rely on that data because we don't know the basis for when that data was collected. Is that right?
Well, I would say that depends on the measurement you're talking about. One of the specific items that I laid out in our presentation to the neighborhood groups and then also to the planning commission was what we call a blast array survey. What you do is you take a series of seismographs and you put them in a line in a certain direction that you're trying to investigate. In this situation, it was Friendship, right? So what it does is it gives you the measurement at point A and then 200 feet, 300 feet, whatever the distance are that you spread them out, right? The ultimate learning from that we hope to share with the neighbors was that it dissipates, okay? It dissipates quickly. And here's how far you are now, here's how far you will be, here's the dissipation that occurs in that sort of window. So it's a fair thing to say that shot isn't going to be felt exactly like every other shot. And he's correct that sometimes the overcast, cloudy
Yeah.
weather conditions can make people feel, let's be clear, the air overpressure, which isn't actually vibrations, but you feel it kind of like you feel a bass drum in your gut when the marching band goes by. It can make you feel more of that because that air overpressure reverberates back down off the cloud cover, right? So yes, there could be a shot that might feel better than that. There could be a shot that might feel not so bad as that. The point of that wasn't to prove that every shot that we ever shot
Right.
you'll love, right? But the other data that we showed with them is that we target half of the legal limit, and we most of the time are at something like 20% of the legal limit in our blast vibration and our blast air overpressure recordings. So what we were trying to do is help them understand the science, and I appreciate your comments about Mr. Butler's time and effort put into this. You know, I think I joked once that we need to find him another hobby because he has been very, very involved.
He's a very dedicated individual.
Yes,
I've appreciated
yes, he's been very
information.
dedicated to this project.
Let me add,
Go ahead.
so one of the, I've heard you say this, not particularly tonight, so, but in prior meetings, so give me the liberty of bringing this up, that part of the problem with the phasing is, just like the land is your inventory, it's hard to know exactly what's in that inventory. And so the phasing makes it difficult for you to move around and commit and all this, but there are things that can be done to confirm that, correct? Core sampling, I mean, you could sample that land and know exactly what is underneath it at any of those locations.
Theoretically, yes. One thing that we shared with the neighbors at both of our group meetings that, you know, we tried to get as many people out as we could is that any of you guys that are involved in the contracting business knows nobody wants to pay 1 penny more for rock than they have to.
Mhm.
This is not a high margin business, okay? We are not creating tech devices here, right? If we wanted to go core that entire property to know exactly where the rock was, we wouldn't make any money mining it because coring down through rock is very expensive, okay? So the idea here is that we know that there's probably a lot of good rock in this area. But when you start mining a deposit, it's very similar to if you've ever seen somebody try to turn a tree into boards of lumber. Sometimes you hit a big knot, right? And so that board's got to go out or you've got to cut it shorter. Sometimes we'll be going in a certain direction and what's been a consistent deposit has suddenly a mud seam in it or what they call a mud cutter, right? And then we might have to just turn, if only for a few weeks, to go in a different direction while we clean that out and then proceed, right? So the initial Butler plan that we saw had 5-year blocks.
Yeah.
This 5 years you get this 5 years you get this 5 years you get. It doesn't work. We can't stay constrained. You have to basically keep multiple options of high walls going, right? So right now, we've got some material left to the north and we're going down to the southeast. So that if we run into a problem in either one, we can turn ourselves and keep production going from the other face. So the idea here would be to move to the north and if necessary to the east, right? And bounce those off each other, but mostly push to the north. Then once we get as far north as we can, go to the east and then come back down to the
Yeah.
south and east toward the lake.
Yeah. The problem I have with an expansion like this is the expense and the inconvenience to you is a difficult thing for me to dismiss. Do you know what I'm saying? Like, just because you don't want to do it doesn't mean it's not a viable thing that can be done to help out, to be
Well,
the neighbor.
Yeah,
The neighbor.
but ultimately, keep in mind that serving our customers is keeping rock and asphalt plants and concrete plants and keeping construction jobs going. So the idea that we can keep continuity on a day-to-day basis of material moving is important to us, just being a going
Yeah.
concern and the construction projects going on in the area.
Not the quorum court's job to ensure your profitability. I mean, that's not, I have to dedicate myself to trying to make this as palatable for everyone as we can, and for everyone to be good neighbors.
I agree, and we're trying to do that too, and I don't mean to insinuate if that, what I'd like to say is that we've tried, as I said, to map out where the rock is on this site. And then we've said to the neighbors, we're not going past this line.
Yeah.
And we've said to Beaver Water District, we're not getting any closer to your lake. This is what this thing is going to be. And then we have some latitude to progress through it the right way. It's because we're getting that big chunk to work in that we're willing to give the concessions we're willing to give, and to show a big picture of here's how this thing can be, and here's how we can work together as
Appreciate
neighbors.
it. Yep. Thank you, Judge Wood. I'll have some questions for the appellant, but I think we'll go ahead and.
JP Ussery, and then JP Simons.
Okay, thank you. And I apologize, I'm the new guy on the block. This is my first quorum court meeting. I'm the old new guy or whatever. The company that I work for, I've worked with quarries for a number of years. And I've got two questions. Number one, I think it's real important for the public that you used a phased approach. While you don't know where you're gonna go, if you're gonna know that this is gonna last you 50 years, I'm pretty comfortable that you've got enough there to last you 10 years no matter what happens. I don't see how you could possibly have that many bad spots in that particular area. It could happen, but I'm just saying that particularly, there's been a lot of effort that's gone into it since the CUP has come up. Prior to that, there was a lot of things that could have been done that weren't done. And to me, there's no accountability. If we give you the next 50 years, you don't have to come back to us again unless things get really wild. And so to keep check and just a matter of accountability, I think that doing a phase is going to be much more important. The second thing is that I know enough to be dangerous about a lot of things, and I'll be happy to admit that. But one thing I do know that as I've talked to a number of people that are in the crushing industry, and there are crushers out there that can be much, much quieter. And I know that it's about $1 million investment, but I also know they don't last forever. And I know that over the next few years, you're gonna have to replace that thing. And when you replace that thing, I strongly encourage you to do your homework, and I'd be happy if you need some consultants. I know Rodgers Group is very big, and it's got people that understand that. But there are crushers that are much quieter, and that I would certainly strongly recommend that you look into that. Thank you very much, and I do appreciate all you're doing.
JP Simons.
Mr. Effinger, thank you for the information that you brought forward today. It's my understanding that you guys have put seismographs and decibel meters in and around the neighborhood to test those levels. If for a moment we work under the assumption that this expansion is not approved, the future of your mining operation is not going to discontinue.
No.
You're going to continue. You'll continue digging deeper and more than likely probably down and underground, correct?
Well, back to what I mentioned earlier about the high cost of exploration compared to the low cost of manufacturing our product. We have not gone through deeper type analysis because we think this is the right thing to do. Whether there is good rock at any certain location below where we are right now, there's uncertainty about that, right? We do have a facility in the city of Louisville that was such a good location that once the surface reserves were exhausted, we went 900 foot deep down in an underground mine under there. So no, I don't think there's any reason to think that our surface operations here are going to cease anytime in the near future.
It just makes me wonder what kind of concerns if vibrations and noise are an issue now. What would that look like when you start going deeper for those the community members nearby.
Actually, if I could just return back to that quieter crusher conversation, if I could add a little bit here. One condition that JP Deacons added in our negotiations that was pretty savvy, I didn't quite understand what he was talking about at first, but he didn't want us to move our crushing plant over into the red area. And I thought, what in the world is he talking about? Move it into the red area? Until it's a pit. So the plan, if this all happens the way this is designed to happen, is that when we do need to replace those crushers, we will put our crushing operations in the pit. Right? For us, it makes economic sense to get the crushers as close to the high wall, right? But right now, it's not big enough. Once it gets big enough, we can put that plant in the pit. And then when we put that plant in the pit, I understand there are quieter crushers. Crushers probably get quieter every year when they make a new model, right? They will be, just based on technology, quieter crushers, and they will be down in a hole. And that's the plan, is that the impacts, given this plan right here, can be reduced significantly. But again, as you mentioned, that's $1 million plus investment. So part of the plan here is to expand out, widen the pit, go in the direction where the reserves let us, and someday when we need a new plant, because things do wear out, put it down in there so that we're doing the crushing in the pit. And that's another reason to go for the entire thing now, to justify the investments we would have to make to be the kind of neighbor we want to be.
Thank you. One more question. Again, operating on the assumption that this expansion is not approved. It was my experience, at least in viewing previous mining operations that came before the Quorum Court last year. If this expansion is not approved, is it safe to assume that litigation might be pursued to overrule this?
Well, I did lay out in the letter to the Planning Commission, and I hinted at it a little bit earlier, this strange situation in the law where zoning decisions end up being more impactful to a natural resource extraction company like us than they do for a normal company, right? If a grocery store wants to add on another expansion to their grocery store, you could get to say no, they still have their grocery store, right? And when the question was raised earlier by the speaker for the appeal, that what else do you approve for this long? You approve everything for 50 years. You approved this brewery earlier. It could be here for 50 years, right? So there is some law in some jurisdictions, and it's not often litigated because typically these kind of issues get negotiated instead of litigated. But there is some law on the books in certain areas that say refusing zoning to an applicant who has held the property, who has set it aside for mining, and who is in the mining business clearly, is something akin to a taking. Now, it all is very, very, very fact specific. When did you own it? What's the evidence that you meant to mine it? Yada, 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 right? So there are some situations, on the one hand, you can't go out and dig up a shovel of dirt the day before the zoning ordinance passes and say, I've got a mine, and now this 500 acres is a mine, right? You can't do that. But given the history of this mine, given what happened in 2003, what happened in 2006, 2012, and now, depending on how this plays out, our strategy has been, when we see reasonable impacts, we will address them with reasonable mitigations, right? And we've tried to be more generous, right, to err on the side of being generous, right? So, again, back to the point of phasing and the hours of operation. To take the hours of operation down now, or to take the phasing back now, does that mean that we could give less of a conservation easement? Or does this preservation area shrink? Or do we then not have to build the screens? So part of this is a complicated haggle that's been going on for a year that you have in front of you now. The question for us will be, was that a clearly arbitrary and capricious enough no vote? Or did they cite something legitimate that we didn't respond to, and did we lose for good reasons because we didn't address a legitimate concern? And that's why I go back to these comments about thoroughly vetted, a lot of conversations, 33 conditions now. We started with 47 conditions. We've got 33 conditions on top of the 20-some we had in the 2012. And if I could just speak for a minute on some of the compliance issues. ADEC and MSHA, somebody mentioned OSHA earlier, we're actually monitored by MSHA. Those entities are required by law to investigate complaints. And when an MSHA inspector shows up at our quarry, if the person sitting in the office radios down into the pit to tell people that MSHA's there, that's a citation. We are open at every day, at every minute, for someone to drop in and check how we're doing from a safety and health perspective. So I cringe a little bit when I hear the comments that we just do whatever we want to do. It's so far from that, it's not even funny. We have to tag our electrical cords to make sure that every extension cord is replaced every year, because it could become a violation. You know, how many people in this room replace every one of their extension cords every year, right? This is the kind of level of safety scrutiny that we are under. We are a highly regulated industry. We regulate our employees for hearing loss, or we monitor them for hearing loss pursuant to regulations. We monitor them for dust exposure. And with an ombudsman and this new GIS technology where you guys can see a new picture of where we are all the time, I honestly don't know what the concern is about some rule we're going to stop following 5 years from now.
One last question. If litigated, and I think you touched on this, those 33 conditions could potentially go away or change in some way.
It would depend on the strategy, and it would depend on how far-reaching a judge wanted to agree with us, yes. But, I mean, it would be a long-shot strategy to say that, you know, Mr. Hunt turned this dirt before zoning, and you guys in the zoning department can just go fly a kite, right? That's one argument somebody could make. I doubt that would work, right? So it's something between that and being here complying. If this is not ratified, those are the considerations we'd have to have.
Okay, thank you.
JP Madison, and then JP Pond.
Thank you, Judge. Thank you for your presentation. I have heard a lot of dirt pits since I've been on the court, including your pit in 2012.
Okay.
And I will say that I think you all have tried harder than anybody else to try to do something
We appreciate that.
works for the neighbors. I wanted to ask you something that I was reminded of that happened, or was said in 2012. And you may know this, I don't. So if you don't know it, that's okay. But my understanding is the county can only regulate the dust that's on our roads, and that anything else would be up to DEQ or some other entity. What are the limits?
Well-
Or who regulates dust in the air?
My guess would be, and I'm speculating, we merged the, it was called Northwest Arkansas Quarries at the time, merged into Rodgers Group in 2003 subsequent to that approval. So we weren't really involved in that application as much as I've been in this one. That kind of commentary probably stemmed from the fact that there was LSD regulation on the books. The LSD regulation for large-scale development requires tarping, and it requires a certain size entrance when you leave the road. So that probably is why they were talking about monitoring the dust at the road, not necessarily monitoring the dust that we make at our crusher. But like I mentioned in the discussion about MSHA, we do annually test all of our workers with a little device that they wear to see what they're exposed to. And anywhere that they're exposed to something close to an action level, we have policies in place where they have to wear a mask to work in those kind of facilities, right? So the issue with the county, and this goes to a lot of different things. It goes to the ADEC water regulations, the empty safety regulations. There is a general rule in the law that a county can't go in and change state rules on certain things or national rules on certain things. So that's probably where that was coming from, is that you guys did require us to turn in our dust suppression plan or our dust abatement plan, and that was one of the conditions. We do have to comply with that dust abatement plan, and I think we have to do that as well pursuant to some of the environmental regulations. So I'm not sure beyond that. what the monitoring of the dust or the regulating of the dust would be.
Yeah, I guess I'm trying to figure out sort of how far, I mean, there's a lot of conditions. It seems like we've gone to great lengths to impose conditions to try to make it work. I guess I'm trying to sort of figure out, like, is that really the county's place or not? I mean, you're probably familiar with our planning ordinance. It's some of them are really easy to meet. The
Yeah.
others are kind of, we can't say, well, we think you're a bad citizen, so we're not going to approve this. We're supposed to look at compatibility, harm on property values, the neighborhood land. I mean, we're pretty limited. So I'm trying to figure out, like, in all these conditions we've imposed, sort of if
Yeah.
maybe we've gone too far.
Well, in my opinion, when you make us comply in your conditions with MSHA and ADEC, which has delegated authority from the federal government, is a state agency, and the remainder of the conditions, that covers a lot of the big picture environmental stuff, right? So getting more stringent on those things would be difficult. That's a conversation we had with Beaver Water District. I think Beaver Water District has some issues with the way we're regulated and wishes certain things were tighter, and that's fine. But Washington County's not going to suddenly hire, water quality investigators and pass a water quality ordinance just to monitor our one mine, right? We comply with those federal rules, and they have the delegated authority, and it's right for you guys to make us comply there. An example, though, to the water quality issue, the violation that was mentioned earlier in the conversation. An ADEC inspector showed up at our facility and asked a person who was a very new employee how they could discharge from the area they were in the plant. He said, "Oh, we could just do this right here." And our dust suppression system started pouring water out toward that creek. Well, that's not how we discharge, and he doesn't have the authority to decide to discharge. The inspector asked him that, and he did that. That's what we got a notice of violation for. Employee's no longer here. That's the kind of scrutiny we're already under.
Well, the last thing I'll say is I think we should only subject people to coming to the quorum court once every 50 years. That's probably a good rule.
I couldn't agree more.
It's kind of painful sometimes.
I couldn't agree more. I don't think we want to do this every 5 years.
JP Pine.
It seems like I do these a lot. It's a point of clarification, actually. Referring back to how many years ago that was when your outfit turned themselves in because you had discovered you were operating outside your permitted area. And maybe I'm recalling, was that not, you weren't actually mining in that area where you had moved into an area outside your permit where you were stockpiling some materials. Is that correct?
Most of it was stockpiling, and this again goes to one of these complicated legal conversations of what is and isn't restricted by certain categories in zoning law, right? So we had permission for 120 acres to be a mine. Then what happened, and is probably worth consideration in this vote, is an asphalt plant was built to the north of us. There's an asphalt plant along Pleasure Ridge Heights there. And as happens at quarries, the piles of material that they buy started moving closer and closer to them, right? So then a road was built up through there, piles of rock were put out there. And this was in that period after 2003 and before 2006. And then after 2006, when we were operating, or when Northwest Arkansas Quarries was operating as a non-conforming use, where you could have a decent argument about what exactly was and was not approved. Going back to that comment I made about a baby elephant and a grown-up elephant. The mine had been approved and zoning was passed later, right? When you passed the zoning ordinance, every business owner in the county didn't immediately have to come in here and get a conditional use permit. But your zoning ordinance is strict enough to where once you're disturbing more of an acre, you pretty much have to come get a conditional use permit. So there was an issue of boundaries, and there also was an issue of what can and cannot be restricted by the zoning ordinance. And that's where there was enough lack of clarity that we decided to go through the process to get clarity.
Well, we've been there long enough to know that we changed rules in the middle of the ball game. We were in a transition period, maybe a nicer way to put it.
Yeah, yeah, and it was uncertainty, and we wanted clarity before we were gonna join as a partner, right? So we got clarity, and then we formed the joint venture.
Thank you.
And we want nothing more than clarity in this approval here.
JP Lemming.
You're in the wrong business.
Oh,
We're
really?
in a tough business, I'll just say that. I haul out of y'all's pits
Okay.
with dump trucks all the time. And I see a lot of things you've talked about that's not true. I mean, plumb from the washing of wheels all the time, plumb from water trucks running up and down the pits all the time. That don't happen all the time. And another thing that we do that we shouldn't be doing is y'all what you call a wet base. You'll have a pile of gravel there and you'll soak it and soak it and soak it in water. When them dump trucks leave, they hit the highway 412 and they scatter water plumb to the job site. And that water that hits the road, it dries. First car comes over, then you got dust. I mean, I don't know how you'll ever stop that. And we was talking about seismographic. These neighbors can tell you about seismographic because their windows is broke, their sheetrock's broke. Have y'all ever helped anybody or fixed any of their problems?
Well, I would say, could I jump back to the first concern first?
Yeah.
Part of what the challenge is, you're right, this is a tough business.
It is a tough business.
But sometimes even the complaints against us are contradictory. So, you know, you just mentioned we don't run the water truck enough, and also that the rock is too wet.
No,
Those are both problems from time to time. Sometimes we don't run the rock truck enough. Sometimes the rock might be too wet. But the water truck is the dust suppression system. That's the way to keep the dust down in the dry time of the year. I wouldn't put it past some of our guys that run our quarries to try to sell a little water too. So the wetter the rock is, the better, right? So that is an issue. Those are things that are hard to be perfect at. We're dealing with a natural product. We're dealing with the outside. We're not in a closed factory. It's hard to control everything that's going on, right? And then the second point you had,
about
the sheetrock and the damage to the property. We encourage anyone who thinks we're damaging their property to turn their damage into their home insurance company. And folks never do.
Well, do you feel like they are to have to go through that problem to turn it into their insurance?
I know I have cracks in my house, and I live nowhere near a quarry. That's the tough part here.
And I've heard the statement that your rock quarry don't make no noise or it runs like a refrigerator and it's quiet. There is no way you can crush rocks and the crusher is quiet. There's just no way. And I think that running 24 hours a day, you know, if you need that much supplies, I think it's time to buy another crusher and put two down there. And the crusher over there at Weddington, how many acres does that little crusher sit on?
I don't know.
I mean, it's got plenty of room down in its hole in its area. And you talk about water, I don't know where it goes, but there's a pump that's hooked up and it pumps water back over top of that hill and it heads south and goes somewhere. And it just looks to me like it heads over the top of that hill down off in the holler. Is that true or where does it go?
The water on our property goes back into our pit, back where that pump is. We pump it up to run our dust suppression system, and everything on the surface is designed to go back down into the pit. And when we need to have a discharge, because there's been a lot of rain, we have to make sure that the water is clean before we do any kind of discharge.
And you was talking earlier about you was trying to talk like you have to run your quarry to keep your pipes from freezing. How many, in the wintertime when it's freezing and there's snowing, there's normally not a lot of activity going on with the needing gravel. I mean, so that's something to say, but I don't think you're gonna be using that much. I don't think you'll be using that much gravel to run at night just to keep your pipes running water to stay free.
Well, you'd be surprised. One of the folks I used to work with compared what we do to selling Christmas trees. You need to have a bunch of Christmas trees a couple weeks before Christmas, right?
I know your
So we get
business.
wiped out in the fall, and then we've got to run through the winter to have the stuff on the ground come April 1st to not be a problem for our customers. And that's a really good window for us to run hard and long and put a lot of product on the ground for the coming spring. So it isn't really about what we're selling right then in the winter.
That's what I said, you're in a tough business. It's feast or famine.
Agreed.
Thank you.
Okay, so with that, we need a motion to either ratify the conditional use permit. Thank you, Mr. Effinger. I think we're at this point, we're just going to go ahead and now and,
Done with me?
yes, thank you. So either a motion to ratify or a motion to deny.
I have questions for the appeal. The gentleman with the appeal.
I'm sorry. JP Deacons, go ahead. And then JP Ecke. JP Deacons?
All right. Thanks, Mr. Goff. I have just a couple quick questions for you. This won't take long. You stated it in your presentation, but your ultimate goal here is not to shut down Hunt Rodgers Quarry.
Oh, absolutely not. We're not going to stand in the way of progress.
You don't feel like the entity has done enough to be a good neighbor over the years? They have no credibility in your mind?
I think they've done enough things. You know, trust is one of those things, you know, it's very hard to build and it's very easy to lose. And they've lost my trust and the people that I've talked to based on their actions in the past.
Here is a representative of the neighbors there. Do you think you've been consistent in your goals that you've set for the quarry? We've heard from the quarry tonight that they felt like you've kind of moved the goalposts on them.
So my goals, you can look at every presentation that I've made, and it's been consistently the phased approach, asking for the same thing, hours of operation, blast survey.
As a representative for the community, do you feel like there's been any significant drop off to the opposition to this expansion?
I don't, and I take objection with what was said that there was only 10 people at the meeting in November because it was a Zoom meeting. So I don't know unless, you know, Nathan or somebody said this is how many people are online, but, you know, I know that the meeting after that, Bill, my neighbor, actually went down and he was the only person live in person in the meeting because it was all virtual. So I don't think that that's an accurate depiction.
Yep. Well, yeah, we know this has been a year and a half long process, and I've told a lot of people this has hung over my head like a dark cloud for a year and a half to make sure we can try to get some sort of agreeable circumstance here. You know, and what I want to say is I want to frame this is using a word from Mr. Effinger, this is a generational sized expansion, and that's what gives me pause about it. And it pains me because, you know, my principles are free enterprise and land rights. And I want to see any business operate as much as they can without the regulation of any government agency to be prosperous and profitable and provide jobs. But, you know, on the other hand, in this unique situation, we have an entity here who clearly has a bad history or a history of being a bad neighbor. And they have received a lot of opposition. And then, for the most part, when we evaluate these CUPs as justices of the peace, they're new businesses. We have to take that new applicant and basically take their promises and their attestations to us as the gold standard. We basically have to trust them. But in this situation, we have someone here who has a poor history. They have demonstrated that they don't keep their promises, that they don't do what they're supposed to do. And if they don't have any credibility with the neighbors, why should they have credibility with us? Now, all that being said, we've learned tonight the mine has done some very good things. They've made some concessions. They've worked with the neighbors. They've planted trees. They put on white noise, backup alarms, all this kind of stuff. But I would pose to you that the only reason they've done that is because they had to go through this very process that we went through a year and a half for.
I would agree with that.
So it's extremely imperative that we as justices outline these conditions as much as we can, because here's the other next thing I've learned of being on the quorum court. Once this cat's out of the bag, it's done. When this leaves this quorum courtroom, we have a very hard chance of ever putting any kind of enforcement on this, getting any additional concessions. anything that can be straightforward is very difficult outside of that. And that bothers me. That really, really bothers me. And we're talking about, I think, the compromise is right in front of our faces. And we've heard it tonight. This gentleman's wanting to give them phase 1 through 3. Mr. Effinger has already said that lines up very well with their map where they're wanting to mine before the screening gets here. And by no contested estimation, that's 30 years of mining. That's a lot. So here's where I'm at. I appreciate all the work from the neighbors and the applicant, and we're right there at a compromise. And that's the best solution we can come up with as a quorum court. It needs to be phased. And I would suggest that we go through what you, as a representative of the neighborhood, have done. Go with 1 through 3. And let's let that vegetation grow up. And let's let them mine for 30 years or whatever it takes to get to that point. And then they can come back for 4 and 5. We can evaluate the vegetation screening at that point. We can evaluate how good they've been through the other things. Maybe at that point the hole's big enough, we can get the crusher in the hole. That all makes perfect sense to me. The other thing is, I'd never heard a good argument against the hours. And I am very much in support of a dusk to dawn prohibition on operations. I think that makes sense. I've never talked to one neighbor out there or one citizen that went with these proposed hours that we have in this CUP. And then finally, the neighborhood committee has got to have some autonomy. That's the only way that works. Mine, very much so, they've said they have a list of who they think's on the neighborhood committee. I'm fine with that being the starting point, but from there on, they need to elect their own representatives, their own leaders, and they need to have some autonomy in the way they operate. Or it doesn't work. There's no real reason to have the neighborhood committee. So my motion would be to table this date certain for 60 days, and I would like to see these implementations, these 3 updates in the CUP, and come back and see us. That'd be the motion I have.
So we have a motion by J.P. Deakins to table for 60 days. And a second by J.P. Lemming. All in favor? Those opposed? Okay. So now that motion fails. So now we need a motion to ratify or a motion to deny, unless there's some other motion but those are the 2 motions. Motion to ratify or motion to deny. We have a motion to ratify. Point of order, go ahead. Let me see.
On
JP
first
Madison.
reading? Aren't we on first reading? Doesn't it need to be advanced if we're going to vote on it tonight?
We have to have the motion. We
We
haven't picked which one we're reading first.
That's correct.
Okay, well, so we need to pick it,
And
read
then
it, and
we'll-
decide what we're doing.
That's correct.
Okay, I
So
just
we-
want to make sure.
Right.
Okay.
So we got a motion to ratify and a second by J.P. Rio Stafford. J.P. Simons.
I just don't want us to forget the proposed, JP Ecke, is your motion to ratify contingent upon the corrections, the scribblers? Thank you.
That's good, thank you. So there's all right, restate your motion then, so make sure we have that.
Ratify the conditional use permit with the Scribner error corrections.
Okay, so we have a motion to ratify the CUP with the corrections that was sent in earlier, second by J.P. Rio Stafford.
We
And,
don't vote on this, I'll read it.
Okay.
And I think the next proper would be whether or not someone moves to
suspend the rules,
move it,
or just let it go to May. Okay. Go ahead, read that ordinance by title only as motion by J.P. Ecke.
This is an ordinance ratifying a conditional use permit recommended for approval by the Planning and Zoning Board for the Rodgers Quarry.
Okay, with that, since it's on its first reading, it'll go ahead and go to the May meeting, unless there's a motion to suspend the rules.
Motion to suspend the rules and advance it to the second reading?
There's a motion and a second to move to the second reading. All in favor? Those opposed? Ms. Patty, will you do a roll?
Patrick Deakins. Lisa Ecke? Sam Duncan? Chandra Washington? Eva Madison? Robert Dennis? Suki Hires? Evelyn Rio Stafford? Willie Lemming? Jim Wilson? Butch Pond? Lance Johnson? Shannon Marty? Sean Simons? Bill Usry? I have 10 for, and 5 against.
Okay,
So it's approved.
that does pass, so we'll go ahead and read, council, read that one by title only.
An ordinance ratifying a conditional use permit recommended for approval by the Planning and Zoning Board.
Excuse me.
Go ahead, J.B. Ecke.
Thank you, Judge. I'd like to suspend the rules and advance it to the third and final reading.
We got a motion to suspend the rules, move to a third and final by J.P. Ecke, second by J.P. Madison. All in favor? Those opposed? One more time, Ms. Patty.
Patrick Deakins? Lisa Ecke? Sam Duncan? Chandra Washington? Eva Madison? Robert Dennis? Suki Hires? Evelyn Rio Stafford? Willie Lemming? Jim Wilson? Butch Pond? Lance Johnson? Shannon Marty? Sean Simons? Bill Usry? Ten for, 5 against. It passes.
All right, council, read that one for the third and final time.
An ordinance ratifying a conditional use permit recommended for approval by the Planning and Zoning Board.
J.P. Ecke.
Judge, I make a motion to pass.
We got a motion to pass and a second by J.P. Ecke and a second by J.P. Simon. Any discussion? Any discussion? Public comments? J.P. Madison.
Thank you, Judge. So this has been a very hard decision for me. I talked to many folks about it and said that I was trying to come in tonight with an open mind because I really didn't know how I was going to vote. And I thought that it would be easier just to abstain because it was hard to pick sides on this one. But ultimately, I was elected to pick a side. And as much as I've been in the neighborhood's position of trying to protect the land around you, I find that this court should not be in the way of people using their property in some respect. We've imposed a ton of conditions. And this is an existing pit. It's really hard for us to say, you can't continue doing what you've been doing. And what I said earlier when I was talking to Mr. Effinger, the prior mining operations that we've considered have been nothing like this in terms of the commitments that have been made to the neighbors. I mean, a 75-acre conservation easement, a dedication of land so that the people will always look outside their back doors and see trees. A lot of us would like that. And so it's a very, very close call for me, but I'm coming down on the side of ratifying it because I don't know how we can deny a business that's already doing this to continue doing it. And my understanding from the investigation I've done is that it's not going to get more intense, it's just going to move. And that the requirement of the barrier being mature effectively becomes a phased plan. And then, the property values thing is important to me, but I can't, people have been living by this pit, buying and selling houses, moving there after the pit was in operation. And so as much as it pains me not to side with the neighbors, this is one where the hard call is, I think, I have to come down on the side of granting the conditional use permit. I feel like they've met the conditions and then some. And all of us are going to have something in our backyard that we're not crazy about. And if I had to pick a circumstance, this looks like a pretty okay one. And I know it will be hard, and hopefully the ombudsman will help you all mediate that process over the years. And I think we've heard enough commitments from the quarry through this process that I think you guys have a lot to come back and say, hey, that guy said that at that meeting, and it's on YouTube. And you can pull it up, and you've got somebody to call. So I hope it all works out. Thank you.
J.P. Ecke.
Thank you, Judge. Serving as Justice of the Peace, I had a vision for Washington County, and that is a county prepared for and conducive to economic growth and development. And part of my mission is to legislate policies for positive influence and economic growth and development. The Hunt Rodgers Quarry is a rock quarry. It's natural resources. We need natural resources for building materials. If we didn't have a rock quarry, we as Washington County wouldn't really be able to grow. We need these natural resources. And for that reason, I am voting in favor, and that's why I made the motion to support the Hunt Rodgers Quarry. We all need building materials. Everybody needs building materials. But where do you go if we're going to stifle every business and say, no, you can't, no, you can't, no, you can't? So for that reason, is for the future of Washington County in economic growth and development and prosperity. Thank you, Judge.
Public comments.
Thank you. I just have a few things to say.
Sure. Ms.
About
Main, tell us who
I'm
you are, where you're
sorry.
from.
I thought everybody knew me by now. Sherry Main, 15574 Richards Road, Fayetteville. I live 1,070 feet from the Hunt Rodgers Quarry in Fayetteville off Hamstring Road. I can have a conversation in my backyard. I mean, I know people hear things in different ways, but the noise they make is not over bothersome. I've adapted to it. It was there when I bought the house. It was pre-existing. It was a working quarry. And so I knew that when I bought and I built and I moved, or we just renovated, but anyway. So, I mean, I think this has a lot to do with you don't want it in your backyard, is what I'm hearing. And I have been on every meeting on this from the beginning in January of last year. Some of the conditions that the planning board, it just kept going on and on and on and on. I mean, I've heard of a lot of these and been involved with a lot of these even way back before I couldn't do anything in 2002 before zoning, where you just had to go out and scream and hope someone listens. Now, there's over 40 conditions placed on this for them to follow and be good stewards. We didn't used to have that. No one could do anything for us back when they were moving dirt and starting this. So I think it's great that you're able to put conditions on this and for the neighbors to see that they are a good neighbor and follow through. They're a good neighbor to me. I don't know if it's affecting my house, but they put a seismograph meter out there every time they blast. And if I want the report from it, they're required to keep it for 6 months. I ask for it, I get it. It has the time of day, whether it's overcast, whether it's cloudy, whether it's sunny, what the temperature is, that's all on the blasting report. I don't know why these people that live in that area haven't done their homework. It's all the information is out there on this. All you have to do is do your homework. No, I mean, who wants to live by a quarry? But if you move next to a quarry, hey, that's your decision. You move there. And like Mr. Gallen, he sold his first lot he bought from Mrs. Hunt after building a house on there for $350,000, turned around on his other 2 lots he owns, built a $650,000 home per his comment in the public comment back at the the December meeting. I listened to them, and I was there. I mean, I was on Zoom. So I'm not just up here speaking on behalf of someone. I'm speaking as someone that is a good neighbor. And Hunt Rodgers has been a good neighbor to me. I have been a good neighbor to them. If I have a complaint, I call. I don't sit on my hands and say, I wish it would get better. If I have a concern, I go to DEQ, look up the rules.
Sorry, Ms. Mann, go ahead and wrap it up.
So all I'm asking is just consider the facts. Look at the facts, not anything outside of the facts. And I think you should approve this. Thank you.
Public comments. Public comments.
Am I on? Okay, thank you. Again, thanks for doing this. Appreciate your patience tonight. It's gone on for a long time. We're probably not going
Go ahead,
away.
give us your name and where you live.
Brian McDuffie, and I live in the Friendship View subdivision. Just real quickly, there was a lot of things covered and some improvements covered, but I don't think any of the really big issues really got talked to. I bought my property before there was a quarry there, but after they knew they were building one. But there was no disclosure, and it's legally required in real estate law, I'm told. I'm not an attorney, but that's what I'm told. And there's a bunch of people that are in that same situation that was not disclosed. It's no different than if you got a furnace that doesn't work when you sell your house. If you know it, you got to disclose it. I didn't hear any talk about that. I didn't hear any talk about fixing that slimy stuff that gets washed around on the road. I didn't hear any talk about how we deal with these, and pretty narrow roads out there, how we deal with all these school buses and traffic where these dump trucks are over the center line all the time. Didn't really hear an answer about the running at night and the noise at night, although I kind of thought there was a compromise that they're only going to run at night when it's below freezing. But I may have had some wishful thinking there, but that sounded like the reason why they run at night. So I think everybody in the subdivision would be happy if they only ran at night when it was freezing. There's just a lot of things that didn't get addressed, got avoided, and I don't know how many you have kids or have had children, but you probably don't put your little kids to bed at 9 or 10 at night. You probably put them to bed a little bit earlier than that. But you can't, those kids can't go to sleep in our subdivision at night. They got to wait till that thing shuts off. And, you stood up in the last meeting.
Just look this way.
Yeah, stood up in the last meeting and said those quarries make as much noise as a household refrigerator. Would you stand up and say that to these people?
Come on. Make your comments this way.
I'm just frustrated, so apologize. Anyhow, I just think there's still a lot of issues that aren't addressed. I kind of see the writing on the wall, but we're not going away. So thank you for your time tonight.
Thank you. Public comments.
I'm Gilbert Johnson. I live at 21629 Friendship View Drive. I'm not going to go back through everything that's already been said, but I just want to make it clear and remind everyone, none of us here are trying to shut down the quarry operations. We're not trying to limit growth in Washington County or future economic success for the Hunt Group or the Hunt Rodgers Group. But it seems to me we can accomplish both things. Well, we've already agreed that, hey, give them 1, 2, 3. That's 30, however many years of mining that they can go ahead and mine and supply all the needs we need in Washington County for 33 years. But at that point in time, before they go into that area 4 and 5, come back to see have they done all the things that they say that they will do and are going to do, and is the process still working? To me, that seems like a very reasonable compromise that works for everyone's benefit, accomplishes the goals of providing materials we need for the Washington County, and also helps satisfy the neighbors in that area. Thank you.
Hey, Mr. Johnson, public comments.
Hopefully one last time for tonight. Kyle Smith from Fayetteville. And I never thought that I would be sitting up here speaking in favor of a billionaire's industrial quarry operation. But land use is a fairly nonpartisan issue, and I'm not going to pass up an opportunity to agree with some of you that I don't get to do that with very often. I want to talk to you about the environment, though, at the risk of that seeming like a more partisan issue. I'm not usually a big fan of or supporter of noisy, messy quarries, but this quarry is already functioning, and we do need quarries. Like Ms. Hickey said, materials for building a growing urban region are an essential part of that. And the city or the county builds roads and bridges, and you need materials for that at a reasonable price. Home builders use these materials. And we're going to continue to need them for decades. So there's four major things I want you to consider. Consider the environmental impact of opening a new quarry somewhere else on virgin land. Consider the environmental impact of transporting materials from farther distances away outside our region if we aren't producing them here locally. Consider the economic impact of jobs lost if this quarry has to shut down in 10 years or even 30 years instead of having the security to go for 50. I don't know a whole lot about quarry operations, but I know things of this scale, there are some investments that you make on a 50-year timetable that just aren't worth it on a shorter timetable without some certainty. And finally, consider the economic impact on private developers, public works, and new home buyers. We already know the home costs in our region are skyrocketing. And adding one more marginally increased expense to that process is not something we need to be doing for our greater population. So thank you for your consideration of the appeal, and I do hope that you will ratify the conditional use permit. Thank you.
Thank you. Public comments. Got about a minute and a half. Public comments. Any other public comments? With that, Ms. Patty, go ahead and take the roll. This is on the ratification of the ordinance.
Patrick Deakins? No. Lisa Ecke? Yes. Sam Duncan?
Yes.
Chandra Washington? Yes. Eva Madison? Yes. Robert Dennis?
Yes.
Suki Hires?
Yes.
Evelyn Rios Stafford?
Yes.
Willie Lemming?
No.
Jim Wilson?
Yes.
Butch Pond?
Yes.
Lance Johnson?
Yes.
Shannon Marty? Yes. Sean Simons?
Yes.
Bill Usry? Yes. This ordinance passes.
Thank you, Ms. Patty. That ordinance passes. Item 15. I'm right? Yes, item 15. Council, will you read that one by title only?
An ordinance appropriating $219,000 from the Coronavirus Relief Fund to the other professional services line item in the Circuit Court 6 budget for 2021.
J.P. Johnson.
Yes, thank you, Judge. I move to approve this ordinance, and if it's seconded, I'll discuss it.
All right, it's on its first reading, so, it's okay. J.P. Madison.
Thank you, Judge. I fully support this funding of the program that you've had to come see us a lot lately. I'm going to support the ordinance and I'm going to vote for it, but I really think that we need to examine its belonging in a court's budget. And the reason being that Returning home is going to be serving individuals that may be offenders out of that court. And if that court were in a position to revoke parole or have some kind of involvement in that particular individual, I don't want there to ever be a claim that that judge had control over the program. And that may seem theoretical, but when it comes to judicial ethics and what might give a criminal defendant room for a challenge, that doesn't seem worth it to me. We just need to move it to a place that's disassociated with any judge that might hear a case of someone that comes to returning home. And I'm gonna support it tonight because you've been waiting too long for this funding. And so I want to get it on out of here. But I think we've got to, at some point, move it to another place so there's not this concern of any kind of conflict or ethical issue for Judge Lindsay in Circuit Court 6. Thanks.
J.P. Deacons.
Thank you, Judge Wood. Mr. Robbins, I want to thank you for being so diligent. I've said several times that this is just a wonderful program for Washington County. It's going to help us with hopefully with our jail issues, and I appreciate his dedication. County Attorney Lester, will you clarify a little bit why that account was selected? I mean, what I've been told is it's essentially a formality. We needed a landing spot for an accounting situation, and that's where it's at. So thank you, sir.
Sure. So there was a lot of discussion between my office and Sheriff Helder's office and then the courts, along with the comptroller's office, about where this money goes. And the reason for that is when we get into legislative audit every year, they really look at where we spend money from and how it's related to whatever it is that we do. And so you could put this in my budget as the county attorney, but legislative audit would probably come back and have a lot of questions about why this came out of my budget, because I don't handle anything criminal or do anything. Same with like the judges. And so for a lack of better explanation, no one really had a really good place to put this. The circuit judge has no control, or none of the circuit judges have any control over this program or how the money's spent, as well as the sheriff. The sheriff doesn't have any control over who goes and who doesn't. And so while we certainly can change that, and you can literally put it, pretty much anywhere you want, and I don't think it's illegal to do so, but just understand that we may get some dings from legislative audit next year about this year, and why this was put into a certain fund. And so I agree, we have tried to find the best place that we could to put it, and because it has to do with criminals or people that have been charged with a crime, and an alternative sentencing, which you really get two buckets there. You get the circuit court system, or you get the law enforcement side. And so, I'm sure we could amend that if anybody had a suggestion or would rather it go somewhere else. I don't think that'd be a
just
problem.
throw this one out, and I can't. I remember all the conversations, but the CSU, is that in a separate? That's in a separate all by itself line. Could a separate line just be set up without it being in anybody's quote unquote bucket? Yes, I think you're right though. The audit will still want to know. I guess they would know why it's there, but again, it then pulls it away from being in anybody's bucket, like the Crisis Stabilization Unit. It just hit me as we were talking about it, but.
Sure, that could happen. That will require an ordinance. And so while you could pass this, I guess theoretically tonight and put it in so that the money is appropriated and the program can begin, next month we would need to pass an ordinance creating a separate line item or separate fund for this particular, then it could go be transferred to there. But it could be done, it just can't be done tonight at this meeting.
Okay, with that, it's on this first reading, so we'll wait till next. Oh, so we gotta keep going, okay. Any other discussion? J.P. Johnson?
No, I move we suspend the rules and move it to, do we have?
No.
You'll have. So you just gotta have the 10. Any other discussion, then we'll go to public comments, and then we'll go ahead and vote. Any public comments? Any public comments? You good, J.P. Johnson? All right, Ms. Patty, let's go ahead and take the vote.
Patrick Deacons.
Yes.
Lisa Ecke.
Yes.
Sam Duncan.
Yes.
Chandra Washington.
Yes.
Eva Madison. Robert Dennis.
Yes.
Suki Hires.
Yes.
Evelyn Rio Stafford.
Yes.
Willie Lemming. Jim Wilson. Butch Pond. Lance Johnson. Shannon Marty. Sean Simons. Bill Usry. This ordinance passes.
Thank you, Ms. Patty. Item 16, Council, will you read that one by title only?
Item 16 is an ordinance appropriating $18,000 from unappropriated reserves in the county library fund to the dues and memberships line item in the county library budget for 2021.
J.P. Deacons.
Thank you, Judge Wood. This is just a line item move in the, the library budget. I move passage. This is appropriation ordinance. I move passage.
Got a motion and a motion by J.P. Deacons, second by J.P. Lemming. Any discussion? Any discussion, public comments? Any public comments? Ms. Patty?
Patrick Deacons. Lisa Ecke. Sam Duncan. Chandra Washington. Eva Madison. Robert Dennis. Suki Hires. Evelyn Rio Stafford. Willie Lemming. Jim Wilson. Butch Pond. Lance Johnson. Shannon Marty. Sean Simons. Bill Usry. This ordinance passes.
Thank you, Ms. Patty. Item 17, Council, will you read that one by title only?
An ordinance reducing the amount of $399,367 from line items in various county budgets and restoring those funds to unappropriated reserves, and appropriating the total amount of $689,930 from unappropriated reserves to various budget line items for 2020.
J.P. Deacons.
This is a accounting cleanup that we have to do at the end of every year after all the bills are paid. I move passage of this appropriation ordinance.
Got a motion by J.P. Deacons, a second by J.P. Duncan. Any discussion?
We say
J.P.
this-
Lemming?
We say it's a cleanup, it's a $290,000.
That's his. Move your mic away from that thing a little bit. There you go.
It's a cleanup, but we go from $399 to, how do we get there, Patrick? I mean, is this, gosh, darn it. Like the employee insurance, is that money that we took back and put back in, or is that money we're adding to it? We adding $263,000 to his pot? Is that the way I see that? Out of unappropriated reserves? And the recorder cost fund, is that, he need 218 more thousand in there to get to that 290? I mean, how do we get there?
Shannon, will you come forward?
Yeah, most of the difference is the employee insurance fund, because they had, they budgeted an amount, but the amount of claims and administrative fees were higher than they budgeted or predicted at the beginning of the year. So 264,000 of the difference is that. So that's the primary difference between the 400,000 and the 690,000.
So last month, it wasn't as solid as it looked like it was.
Well, it's just, HR just didn't budget as much as they thought the expenses would be, but the amount that they reported on in the insurance funds were correct. They still have the 3.2 million surplus that went up to 3.4 million, I believe. So the fund is still solvent. It's just when they,
So there's $4 million in the account more than, but you're still asking for 263 to go in there?
Well, the insurance fund that they reported on in the Budget and Finance Committee went from 3.2 million to 3.4 million in reserve to cover the insurance expenses. And this amount is just what HR budgeted or predicted. They came up short. I mean, they budgeted less than it came in as actually being. And Director Watson gave an email to explain how that happened or why it happened. But as far as the solvency of the fund and the amount in the fund, it's still strong and solvent. It's just, for budgeting purposes, they didn't predict the amount that they missed their prediction on the budget, probably by
But the predictions, is that through employees that's actually there or actually not there? I mean, how do we get that? I'm more confused than I was.
Well, the insurance fund, they budgeted a certain amount, but the actual expenses were more than they budgeted for. But yet overall, the fund is solvent. And probably Watson could explain that better than I could, but he gave an email that explained it, and it's basically, I could forward that to everybody.
Oh, he didn't send that to everyone, he just sent that to you?
Yes.
Okay, yeah, why don't you send that out to everyone in case they did have questions?
Okay, and that's the main difference, because this just accounts for, since the Quorum Court has it's their domain over the budgeting, so when things go over budget, this discloses that and cleans up the budgeting part. So that's the purpose of this ordinance.
Okay, I understand that. So you're putting 263 more thousand into the insurance fund that's already got 3-point-some million in it. Is that correct? Or does that make the 3-point-some million?
Well, it's not really changing any of the actual numbers. It's just they didn't budget enough for the charge, so.
Okay, let's go on. Golly.
Okay, but that's the way I understand it.
Hold tight, Shannon, JP Deacons.
This confuses me, and I'm a CPA that's been practicing for a long time. Government accounting is a different animal. We always got to keep in mind there's a difference between budgeted and cash, what's there and what we spend. So the county operates off budgeted amounts. The insurance fund under budgeted by, you correct me, you just jump in if I'm wrong. They under budgeted for this amount. So what we're doing is we're closing out excess budgets in some accounts and zeroing out that over budget amount. But that's why he's saying the numbers don't actually change, because the cash is still always there. Does that make sense? There's a difference between budget and cash. I mean, that's the best way I can explain. I know
This is 2020.
Yeah.
This is 2020.
This is for 2020, right?
Right,
I get you. It's just a closing out entry for 2020. Yeah,
Right.
I got you.
The county has, the comptroller's office does with our paper funds, right? With what we see on paper, the treasurer's office deals with our actual cash. And so this is a reconciliation of our books, which sometimes our book numbers are off. We have to reconcile those to, it's like reconciling your checking account. Sometimes your checking account, you miss something here or there, there's an issue, you have X amount of money in the bank, and you've got to reconcile your checkbook to get to where that number is and fix those errors. And that's kind of what we do at the end of the year, or the county's always done historically, is a reconciliation process. And those numbers are big because we're dealing with $65 million, $68 million.
Yes. All right, so we got a motion on the floor by JP Deacons to pass, and it was seconded by JP Duncan. Any public comments? Thank you, Shannon. Any public comments? All right, Ms. Patty, go ahead and take the call. Roll.
Patrick Deakins. Lisa Ecke. Sam Duncan. Chandra Washington. Eva Madison. Robert Dennis. Suki Hires. Evelyn Rio Stafford. Willie Lemming. Jim Wilson. Butch Pond. Lance Johnson. Shannon Marty. Sean Simons. Bill Usry. This ordinance passes.
That ordinance passed. Thank you, Ms. Patty. Item 18, Council, read that one by title only.
An ordinance adjusting carryover revenues in various funds for 2021.
JP Deakins.
Cleanup ordinance? No. So at the end of every year, there's carryover amounts in the budget, and we have to roll those to the new budget because we've already budgeted that money. We included that in our planning for the budget. Right? So this just closes out 2020 and rolls it into 2021. I move a passage of this appropriation.
Okay, man, we got JP Deakins with a motion to pass, a second by multiple. We'll go ahead and give that one to, was that Shannon Marty, JP Marty? Any discussion? Any discussion? Public comments? Public comments. Ms. Patty, will you go ahead and take the roll?
Patrick Deakins. Lisa Ecke. Sam Duncan. Chandra Washington. Eva Madison. Robert Dennis. Suki Hires. Evelyn Rio Stafford. Willie Lemming. Jim Wilson. Butch Pond. Lance Johnson. Shannon Marty. Sean Simons. Bill Usry. This ordinance passes.
Ordinance passes. Thank you, Ms. Patty. Item 19, Counselor, will you read that one by title only?
An ordinance de-appropriating surplus amounts from full-time salaries for various departments and restoring those amounts to unappropriated reserves as required by the 2021 budget controls for the first quarter of 2021.
JP Deakins.
So as part of our budget controls, any unused salary and wage amounts in any budgets get swept at the end of every quarter and go back into unappropriated reserves. This is for the first quarter of 2021. I move passage of this appropriation ordinance.
We have a motion to pass ordinance 19, seconded by JP Wilson. Any discussion? Any discussion? Any public comments? Any public comments? Ms. Patty?
Patrick Deakins. Lisa Ecke. Sam Duncan. Chandra Washington. Eva Madison. Robert Dennis. Suki Hires. Evelyn Rio Stafford. Willie Lemming. Jim Wilson. Butch Pond. Lance Johnson. Shannon Marty. Sean Simons. Bill Usry. This ordinance passes.
All right, that ordinance passes. We'll move on to item 20. Council, read that one by title only.
An ordinance appropriating $332,206.34 from the Coronavirus Relief Fund to various line items in the Buildings and Grounds budget for 2021.
All right, JP Deakins.
Move passage of this appropriation ordinance.
We have a motion and a second. Any discussion? All right, let me go, let me see. JP Madison and then JP Hires.
I would move to sever out the ionizers and have that be a later vote. We received a plea from Judge Lindsay today to support his courtroom improvements, in part because since the Finance and Budget Committee left, the Supreme Court did come out with their per curiam. And so we now can be assured that the improvements that were slotted for his courtroom are absolutely necessary and need to begin in due course. I would also think that the plumbing is sort of a secondary function to jurors and parties being in the building. I'm just not still convinced of the ionizers, and I don't want that to harm the other things, so I'd move to sever that portion out and vote on those separately.
All right, there's a motion to amend the ordinance. So there's a motion to sever and pull out, and a second by JP Hires. We'll do that one. All in favor? Those opposed? All right, Miss Patty, let's see where we are.
Patrick Deakins. Lisa Ecke. Sam Duncan. Shonda Washington. Eva Madison. Robert Dennis. Suki Hires. Evelyn Rio Stafford. Willie Lemming. Jim Wilson. Butch Pond. Lance Johnson. Shannon Marty. Sean Simons. Bill Usry.
All right, so what was that count?
4, 4, and 11 against, so it
Okay.
fails.
All right, so the original motion is on. Let me just say that I think, I can't even remember how long ago, maybe it was Finance and Budget where J.P. Washington asked a question about the ozone, and it was found that it will not, and we can push that information to make sure you guys are aware that it will not harm the ozone. But I just want to make sure, so if you're voting because you think it does harm the ozone, I want to make sure you did know that it will not. But anyway, there's a motion on the floor, a second. Any other discussion? J.P. Hires and then J.P. Washington, J.P. Madison, then J.P. Washington.
Thank you, Judge. I was really hoping that we could sever those because I can definitely support the renovations to the courtroom. I know that they're necessary, but I take a lot of issue with both the plumbing expense of $14,000 and the $216,800 for the turnkey ionizers, and I'm gonna tell you why. All the research that has come out about how COVID is spread, touching surfaces is not one of the ways that they have found that there is significant spread. So I really take issue with the fact that we just did all of this work with Johnson Controls, but we're just gonna come in and rip out and replace all of the faucets and the toilets to be touchless because we're concerned about that when it's not really a thing to be concerned about. It seems like a waste of taxpayer dollars. As far as the ionizers go, one of the things that really concerns me about that is that once taxes are added, $29,000 in taxes, it comes to $216,800.76, and that does not include, according to page 60 of our document, it does not include ionizers for equipment not listed. It does not include overtime labor, holiday labor, repairs to units found to be non-functional, connection to the ionizers to any external control system or monitoring systems, extra labor for inaccessible units due to the fact that this is sight unseen. There's also a 5% price add to cover any co-op fees. Then there's also a clause that says each person supplying material or fixtures is entitled to a lien against property if not paid in full, even if the contract price may have been paid. And all of this with not actually knowing what the cost of this very expensive project is going to be. And the CDC has come out and said that these have only been tested in laboratory settings. They have never been tested in real world settings. So I have a real problem with spending this kind of money on something that we have absolutely no proof, no guarantee that the cost is actually $216,000 and that it's actually going to have any benefit for us at all. Thanks.
J.P. Madison and then J.P. Washington.
So I think we could have had a lot of questions answered at the Finance Committee that would have cleared up some of this. They weren't answered. They haven't been answered. I was really hoping that we could just manage to get the judge's funding through because he needs it and not hang up his funding with these other issues that warrant more discussion. But I understand that's not the way the game is played these days. But I'm gonna have to vote against this because I, along with J.P. Hires, cannot justify these expenses without further information. So I'm finding myself compelled to vote against the necessary funding for Judge Lindsay's courtroom because we couldn't manage to sever it.
J.P. Washington.
Thank you. I just echo the sentiments of J.P. Hires and J.P. Madison. Just in reading through this proposal, it does concern me because there is no estimation for maintenance costs. So what is it going to cost us next year? What is it going to cost us 2 years from now? So I was very concerned about that. And my concerns with the ionizers was not that it damages the ozone layer, but there have been reports that it actually produces ozone. And and free radicals, which is an issue. And I've looked and I've not been able to find any scholarly article that supports the fact this particular technology is better than filtration. The only paper I was able to find was by the president of Global Plasma Solutions, and they're the people that manufactured this. So I just really felt that on this issue, that it's our responsibility to do our due diligence, because we don't want a situation where in the next year, you have county employees and members of the public who are having adverse health reactions that can be traced back to something that has never been tested in a real-world setting. I just think that it's very unfortunate. I really wish that we would have voted to sever. I would hate to hold up these much-needed renovations, but also I think it's irresponsible for us to go forward with something that we really don't know that much about, that really could have been cleared up with someone saying, well, this is why we chose that. And another thing that I just found interesting was that the original proposal for this was submitted in November of 2020, before we even knew that there were going to be renovations. So, this is the part that is really making me not be able to support this. I just think that we need to do our due diligence and make sure that the technology that we're using is going to be safe. And based on the information that I found, we don't know that.
JP Rio Stafford.
Can we table this for 30 days until we get some of these questions answered? I move to table this ordinance.
We have a motion to table and a second by, who's that? JP Hires, JP Madison, JP Hires. All in favor for 30 days? Those opposed? No. The noes have it. Okay, we're back at the original motion. Any other discussion? Any other discussion? Counsel, you said you had a couple questions or answers to some questions?
Yeah, I wasn't at the finance and budget meeting because I was out of town, so I couldn't answer questions. JP Washington, to yours about the ozone, I can get it to you. It's certified not to create any ozone, these ionizers. The reason that we looked at these is there's a couple of different options. One of the options you see are the ultraviolet lights that you'll see at places. The research has shown that these are much safer. These are ionizers. They shoot ions. They grab onto the particles. They weight them so that they get caught in the filters. And so it's the air we're breathing that then gets filtered through our filtration system. The ultraviolet lights are dangerous. The reason they're covered wherever you see them is because they can do substantial damage to your eyes. We had some guys from Johnson Control in. We have some of those in the animal shelter. And from what I was told is we had a guy from Johnson Controls or a subcontractor or something that was doing some of the install who started to he was having retina burn. He didn't realize why. It was because he was above those lights where they were covered in their air filtration system, and it was really burning his eyes. These are things that that were looked at or we began to discuss at the end of last year about what our options were, what we could do. If we had the ability, what could we implement in county buildings to better prevent the spread of something like COVID, the flu, any other bacteria or any other virus that's in the air. This is, we'll target all of that. It's not just COVID related. And so that was the reason that we've looked at and we're looking at this ionizer, is because it seems to be the safest method of what's out there. These guys are on a state contract bid, which means they've already bid this project to the state. That's the reason we can do this without having to move forward with bids. We certainly can bid it, but bidding takes more time. And so if we're talking about courts resuming May 1st and us having more people inside the courthouse, in the administration's opinion, time is of the essence to get some of these things taken care of, to do all that we can to minimize anybody's exposure to anything that's going on, and this will allow us to do it. The fixture issue with the bathrooms, that was not a Johnson Controls issue. We didn't enter into an agreement with Johnson Controls to come in and change our fixtures or anything in our bathrooms. As far as the water was concerned, it was only to come in and help limit the flow of water so that we're more efficient, we're not wasting as much water in our system. We won't be ripping any toilets or any faucets out. We will be adding sensors on to the current things that we have, which are battery operated. We could go in and do them where they're hardwired in. It would take a whole lot more money and a whole lot more time. But in the interest of trying to help people with the spread of germs, that was just another option that we looked at that we could do now. As we, continue, I think we continue to get more data. We get more data on the vaccinations all the time. We get more data on the effects of various strands of COVID. I mean, I know things are emerging and they're going, but as we look to open up the courthouse and county buildings, we are looking to do all that we know how to do now as quickly as possible if it looks like we're getting ready to start having a lot more people in and kind of resuming, getting back to normal. And so those were the reasons behind doing what we've done and what the research has shown. And I did get this product is certified to create zero ozone, these ionizers are.
Thank you. JP Ussery.
Okay. I won't repeat everything they said, but I actually sat down with Dwight and asked him those questions, and Dwight was very, very happy to go through them and answer all the questions. The only additional thing is that they looked at filtration, and the filters, you would have to replace them all the time, and it would just be very expensive for them to do that. This was absolutely the cheapest way to accomplish what we were to accomplish this way. So, thank you.
All right, any other discussion? Public comments? Public comments? All right, Ms. Patty?
Patrick Deakins,
Yes.
Lisa Ecke, Sam Duncan,
Yes.
Shonda Washington, Eva Madison, Robert Dennis,
Yes.
Suki Hires, Evelyn Rios Stafford, Willie
Yes.
Lemming, Jim Wilson, Butch Pond, Lance Johnson, Shannon Marty, Sean Simons, Bill Ussery. I have 9 for, 4 against, and 1 abstention.
All right.
It'll go to second reading.
Next month, it'll be on second reading. Our item 21, yes, item 21. Council, read that one by title only.
Item 21 is an emergency ordinance calling a special election on the question of the levy of the annual dues of the Boston Mountain Fire and Rescue Volunteer Fire Department for fire protection services and prescribing other matters pertaining thereto.
JP Wilson.
Mountain Fire and Rescue Volunteer Fire Department to put their dues on the tax statements. It's important to note that even if this passes by their patrons, these dues remain voluntary, meaning that a taxpayer can decline to pay the dues without becoming delinquent. It needs to pass this month in order to allow them to have a special election in July, or they will not get to do it this year. I move for the suspension of the rules so that this item can advance to second reading.
It's an emergency ordinance, so it can pass with 10 votes tonight. I will let everybody know there's a Scrivener error on this one and the next one. Under Article 2, you can see at the top of the screen here, at the bottom of the box where it says whether or not the dues of the Boston Mountain Fire Department, beginning with, it should say 2021 taxes due and payable in 2022, because the tax season has already started for this year, and so that was just 2 incorrect dates. So this one and the next one, they're just errors that we'll make, or Scrivener's errors that we can fix before we publish. It'll say 2021 taxes due and payable in 2022.
Got it. All right, so we have a motion and a second. JP Lemming.
That's a good deal that the volunteer fire department in Lincoln, when we went to that upped our tax collection about $50,000. It really worked good for us. And another thing, the volunteer fire department don't have to sit there and lick stamps and do all that work, and the county does a good job doing it for us, and it works good. So it's a good deal. Thank you.
So we have a motion and a second. Any discussion? Any discussion? Public comments? Public comments. All right, Ms. Patty?
Patrick Deakins,
Yes.
Lisa Ecke, Sam Duncan,
Yes.
Shonda Washington, Eva Madison. Robert Dennis. Suki Hires. Evelyn Rio Stafford. Willie Lemming. Jim Wilson. Butch Pond. Lance Johnson. Shannon Marty. Sean Simons. Bill Usry. This ordinance passes.
Item 21 passes. Thank you, Ms. Patty. Item 22, Counselor, will you read that one by title only?
Item 22 is an emergency ordinance calling a special election on the question of the levy of the annual dues of the Sunset Volunteer Fire Department for fire protection services and prescribing other matters pertaining thereto.
J.P. Wilson.
Fire Department requests that this that they be allowed to have a special election to put this on their tax rolls as well. It needs to pass this month or it won't be able to be voted on in July. I move for approval.
Got a motion and a motion by J.P. Wilson, second by J.P. Lemming. Any discussion? Any discussion? Any public comments? Any public comments? Ms. Patty?
Patrick Deakins. Lisa Ecke. Sam Duncan. Shonda Washington. Eva Madison. Robert Dennis. Suki Hires. Evelyn Rio Stafford. Willie Lemming. Jim Wilson. Butch Pond. Lance Johnson. Shannon Marty. Sean Simon. Bill Usry. This ordinance passes.
Item 22 passes. Thank you, Ms. Patty. Item 23, committee reports. Let's go. County Services had no meeting, finance and budget. J.P. Deakins.
Reports in the packet.
All righty, thank you. Jails, law enforcement and courts, J.P. Johnson.
It's in the packet.
All right, and personnel, J.P. Ecke, but I think J.P. Pond stood in for J.P. Pond.
It's in the packet. One item of business, we did a pay adjustment for the circuit clerk's office.
And with that, meeting adjourned.